Hey, hi, welcome in. So I have a very small treat today. I am live on a Friday. Y'all know I don't do Friday lives very often, but it is a Friday night. You will hear some shooting in my background as it is Friday. Hector's home, and y'all know he likes to fight zombies on Friday night. So it is what it is. So we get to listen to zombies a little bit. I'll mute, when we're doing trial, but you got to hear it when I'm talking. Meat's loose. So he's out running the streets, being the horrible dog that he can be. Lola's in here, laying down, being good. So, with that, and also the other thing I heard today that I wanted to share before I got started was, let me find it. I'm gonna share it real quick. They were that Emmanuel Haro, the little boy that was missing. They have arrested his parents today, Jake and Rebecca Haro. They were arrested, and there was a massive operation going on at their home, searching and uncovering anything they may find. I hate to put out anything that I don't know as facts, but I do know the parents were arrested. I do not know if they found anything. So that's the story with Emmanuel. I just wanted to put that out there that the parents were arrested today. So with that, I am going to hit play on this if I can find out where it's at.
Your Honor, I have made contact.
Has the state had an opportunity to make contact if they so chose?
We have not, and we don't need to.
Okay.
I'm going to pause. I didn't realize I had gone that forward. So we're going to back it up just a little bit when they first start talking because I don't want to miss anything.
For Wolfenbarger? No. 979. Okay. Case number 24 SC 004201. I'll note for the record that Mr. Wolfenbarger is present here in the courtroom along with his counsel, and that the state's counsel is also present. I am told that the wayward witness is here, Mr. McDermott.
Yes, Your Honor, I have made contact.
The wayward witness has arrived, y'all.
If they so chose.
The one that didn't want to come. Hey, Sydney,
Okay.
how are you?
Is that witness up?
Yes, Your Honor.
Is that witness in custody?
Yes, Your Honor.
Okay.
Oh, he's in custody.
My general understanding
Okay,
is
y'all,
the
see?
Sheriff's Department prefers
I love
to
it.
have witnesses that are in custody to bring them in and have them placed on the stand rather than walk them through the courtroom. So if we could go ahead and do that and get the witness. Do we have any other matters while we're taking care of that we need to take?
Do y'all want me to turn the volume up?
The witness on the stand.
Can y'all hear okay, or do I need to turn the volume
from
up?
The state?
Nothing from the state.
Anything from the defense?
Nothing from the defense.
Okay.
Yes, Denise. Yes, I heard, baby.
So just to be clear,
it was
Mr.
horrible.
McDermott, I'm still going to ask you to call your next witness, and then I'll just acknowledge that that witness is already on the stand, and then we'll swear them in as normal.
Do you want me to ask on the record permission to treat her as an adverse witness? Or
Y'all want me to turn it up, or is it loud enough? I feel like I can't hear, but that might just be me.
I think she's your witness, so you should make an effort to see how cooperative she's going to be, and only if she's not cooperative would you then be justified in asking to treat her as such.
So they're going to actually bring in the witness, put him on the stand.
Good morning. Ma'am, if you'll come over here to the witness stand.
Oh, and it's a woman. Y'all, shame on her. She's in shackles.
And she might need some assistance getting up onto the witness stand and situated in the chair. You could. Thank you very much.
She was arrested.
Okay.
She's in shackles.
So we have our witness, and so I think we're ready for the jury, Deputy.
Okay, so they're bringing the jury with her already on the stand so as not to alert the jury she's in custody. But look at the clothes she's in. Y'all, look. Y'all, look. Look. They're gonna, this is so awkward. It's so awkward. I need to know what she knows, y'all. This is the nosy side of me. Okay, bring in the jury, guys. Okay, y'all.
Defense calls
Yeah.
Wendy Waddell.
Okay.
Wendy
Ladies and
Waddell.
gentlemen, as you can see, Ms. Waddell is already on the witness stand. Ms. Waddell, if you can, please raise your right hand to the best of your ability. The deputy will swear you in.
You swear affirm to the testimony that you're about to give the truth, the whole truth, and nothing but the truth.
Y'all, they told her raise her hand to her best of her ability, and she's in handcuffs. So they're going to see that. They're going to know she's in cuffs. They're going to know she's in custody. How are they going to get around that?
These statements very coordinated for the court.
Wendy, W-E-N-D-Y.
And if you could do me a favor and scoot up a little bit so I can hear you in the microphone.
And Waddell, W-A-D-D-E-L-L.
Thank you very much. Go ahead, Mr. McDermott.
Ms. Waddell, suffice it to say you don't want to be here. You need to answer audibly.
You're right.
Did you know Melissa Wolfenbarger?
I did.
And do you know the Patton family,
I do.
Carl and Norma? And how did you know them?
My parents grew up with them
And did you live next door to them at one point?
as a child.
And were you at one point friends with Melissa?
I was.
Did you go over to her house frequently?
Every weekend. Every weekend.
Thank you. Do you remember something about their house that made you not want to go over there?
Yeah.
And what was that?
It smelled.
Why did it smell?
Well, people just have a smell.
What was the smell like?
Like a person that
Like
stinks.
body odor?
I mean, it wasn't nasty. She wasn't a nasty person.
Was it an offensive smell?
Any smell's an offensive smell.
Did you remember telling
Are
me?
you asking if she was a nasty person? She was not a nasty person.
I'm not asking if she was a nasty person.
Okay.
I'm just asking about
What
facts.
in the hell?
Do you remember speaking with me on the phone a couple of weeks ago?
Yeah.
And do you remember telling me that the smell pervaded the house and
I
the
did.
car
I got on the car.
and
Got
it
on the
stuck
house.
on everyone in the house?
It did.
Including Melissa. Did you remember telling me that people bullied her for it,
They did.
picked on her? Do you remember telling me that Melissa had some kind of, it's not a leading question, Your Honor, unless it suggests an answer.
I'm going to overrule and allow it. Go ahead.
Do you remember telling me that Melissa had some sort of skin condition that caused her to have marks on,
Intigo.
and it caused her to have visible marks on her body all the time?
Yep.
And how did you describe those marks? What did they look like?
Scratches.
Did you say bug bites, sores? Thank you. Can you remember how you described Melissa's personality to me?
Well, if I'd look back at it, I'd say autistic.
I'm sorry.
I said, if I had to look back, I would say autistic. She
Okay,
would be autistic.
but you're not a doctor, right?
I'm not.
So you can't diagnose her with autism.
Yeah,
But what made you arrive at the conclusion that she may have been autistic?
just the way she is.
Let me describe those facts.
You know what an autistic person is. I mean,
Was
there's
she quiet?
sure.
Was she shy?
Yes.
Was she
Yeah,
reserved?
this isn't going to go
She
well
was.
for
Did she
her.
sometimes react?
She whined. She cried.
She whined and cried even when she was older. So are you suggesting she may have been a little bit
Like a baby.
infantile for her age?
Yeah.
You described to me a period of time in which she would visit her Do you remember describing a time to me when you would visit her almost every day,
Every weekend, yeah.
and that you would be locked in the room with her?
Yeah, growing up.
And did you tell me that the door locks would be reversed
It
on
would
her
be.
door, so that the lock was on the outside?
It was.
And do you remember that she was telling me that she was locked like that every day, all day?
Objection needed, Your Honor. He's giving the answers.
Wait a second for Kent to
Overruled. Go ahead.
Do you remember telling me that she was locked that way every day, all day? I need an audible answer. I'm sorry.
Yes.
Thank you.
So was her sister. Her sister's right there.
And from what ages do you remember her being locked in the room?
Stop throwing other people into the converse. This girl, y'all. Yeah, she's gonna test them. She's gonna push them to a point. She's got a really bad attitude to be doing this.
I don't know, 12, 13.
Did you remember telling me it was started at about age 7,
I'm sure it started early.
went
yeah.
up to about 12?
Yeah.
Okay. You said her sister was locked too,
He's right there.
and she was locked up too.
Mm-hmm.
And
I'm sorry, was that a yes?
Yeah, my mom used to sneak out with her and get her out of the window.
Thank you.
what's your mom's name?
Terry.
Terry Archer, is that correct? And
Is that a yes? You're
Yes, it
nodding.
is Terry Archer.
Thank you.
what was your father's name?
Bobby.
Bobby. And you said that your parents were wealthy
They are.
and that they paid to be involved in several activities with you.
They did.
What kind of activities?
GYOP. Georgia Youth on Parade. Girl Scouts.
You remember telling me that anything you did, Melissa
He did.
had to do,
That's right.
and that your mother paid for it. You remember telling me that looking back on the way she was treated, being locked in her room and being deprived. Well, let me back up. When you and Melissa were locked in the room, were you allowed to come out during the day? Were you allowed to get drinks of water?
Hang on. Yeah, you're shaking your head. Is that a no?
No, we weren't allowed to come out.
And were you allowed to get a drink of water?
Yeah, we can get, what was they were thirsty?
Okay. You remember telling me that looking back, you would consider that she had been abused and neglected.
Yes.
Today, if someone were treating their child like that, would you call DFACS?
Relevant, Your Honor. Objection.
Probably.
Hang on one second. Sustained. Go ahead.
Now, did you move away from Melissa's house at some point?
They moved away.
Journey, this is the girl that wouldn't come in yesterday. This is the girl they had to send the arrest warrant out for, and she is in custody. They didn't want her to be walking across in her shackles and chains in front of the jury, so they put her on the stand before they started and brought the jury in. She has a very bad attitude, and she is highly angry. You can tell by her demeanor and the way she's acting, and she's bringing up all kinds of craziness. So
They moved away? Okay. And about what age were you at that point?
I quit hanging out with him when I was 13.
Okay. And you told me a couple of events that happened with her before you quit hanging out with her.
She lost her virginity.
And how did that happen?
Objection. Relevance.
Sustained.
Okay. May I approach your Honor?
Sure.
I would have screamed relevance too. What does her virginity have to do with the price of anything? Hey, Indy, how are you, love? How you doing? We have a woman on the stand that is just out for blood. She wants blood and guts today. She's got an attitude. She is testing them hard, Cindy. And they approach, so with the luxury of zoom, let's get to it, because I need to know.
Do you remember telling me that myself. Was there a time that Melissa did drugs with you?
No,
Okay.
I was doing drugs.
Okay. And because you started to do drugs,
I
you
quit hanging
decided
out with her.
not to hang out with Melissa. You need to let me finish my question. I know it's kind of slow and tedious, but that's just for the record. You got to let me finish my question and then you answer it. Okay.
Can I ask a Gen X question?
Do you remember something? Do you remember at some point Melissa started running away from home?
After I quit hanging out with her.
Okay.
Is that an
And
earring?
do you remember that there was something that led up to her running away from home?
Her her sister had a,
I know that's just me being nosy, but I'm trying to tell if this is an earring or not. And I'm just being nosy. I'm just being me, and I'm being nosy because I'm just like that. But I was trying to see if it was an NX question. I was reading a Gen X question. Well, I mean, I don't know. Is this an earring? Is it a mole? Is it a new type of piercing? I don't know. And I'm just asking. I just it's in the it's in the wrong place. I don't know. It's a mole. Okay. So that's what I'm like. I was trying to figure it out. So I'm just looking. Just me. Sorry.
still baby. Her sister had a,
Her running away from home. At what point Melissa started running away from home?
after I quit hanging out with her.
Okay. And do you remember that there was something that led up to her running away from home?
Her sister had a still baby.
Do you remember after Melissa was gone that she did not keep in contact with her mother?
I don't remember that.
Do you remember telling me that you don't remember her calling her mother? In fact,
Don't say that.
okay.
How I know that?
And had you ever met Christopher Wolfenbarger?
Never.
No further questions, Joe.
Thank you. Ms. Hilton, questions for this witness?
He brought her in for that. He brought her in for that. That was it. Y'all.
Do you remember telling me that when you knew Melissa and hung out with her, that her mother would not let her have anything like makeup?
Mm-hmm. Is that a yes?
Yes.
Thank you.
And what did she do instead?
Use colored pencils.
Do you remember whether she was allowed to have feminine products?
Yeah.
You remember telling me on the phone that she had to use socks.
No.
If I showed you a transcript of our discussion, would that jog your memory?
Why would I say that?
Can I show you a transcript of our interview?
Sure.
But wait, is the defense still talking
I
to
never
her? This
said
is
that.
Mr. Ponytail.
Would you like me to play the
Mr.
audio?
Ponytail's still up there.
Sure.
I thought they were done. I thought he said no more questions. I'm so confused.
I must have been high.
Y'all. Oh. Case one. I didn't see case one. Oh, she is here. I did see case one.
Permission to share, Your Honor?
Granted, just make sure that what you're going to share is only the portion that is relevant to the question you just asked.
Could imagine she was traumatized.
She was traumatized. She was. And let me tell you, like, makeup, when she would put makeup on, she would have to use color pencils because her mama did not give her those things.
Oh.
You know, like she, you know, would have to use, I hate to say it, but like socks for pads and shit like that. You know, because her mama neglected.
I guess I did say that. That was her.
No further questions, Your Honor.
Thank you. Ms. Hilton?
Good morning, Ms. Martin. How are you?
Withdrawing.
Withdrawing. Okay, but you answered his question.
Sweetie. Oh, y'all, I had no idea we were going to. Yeah, if body language was a thing, if it was a thing, it's all over her.
Have you and I ever met? Is that a no for the record?
No.
And have we ever talked on the phone?
No.
Okay. And you spoke with Mr. McDermott a few weeks ago over the phone? Is that a yes?
Mistake. I thought it was you.
Oh, no problem.
But go ahead.
But you talked to him about a lot of different things. Is that fair to say?
Yes.
Okay. And so you were her next door neighbor, correct? Melissa's next door neighbor.
As a child.
And as a child, that from between the ages of 7 and 13?
No.
What were the ages?
Ages of 2 to 7.
2 to 7. Okay. And your parents?
Ma'am, 2 to 7, and she left because her sister had a stillborn baby and ran away. Was that at 7? This timeline isn't working for me.
Are friends or were friends with Melissa?
Our friends.
And you said you spend time at her home every weekend, correct?
Did.
And you just testified that there was an odor in the home that you didn't like. Is that fair?
So yes.
Yes.
Thank you.
But every weekend you would still go to the house.
Yes, I love them.
And I think you testified earlier that your mom would have to take Tina out the window.
She would.
Okay. But your mom still let you go over there every weekend.
She did.
Now, you said that Melissa was able to do Girl Scouts with you. I think you told defense counsel over the phone cheerleading, and then you just said like a girl youth group. Is that the third thing you just said?
Something like that.
And it's safe to say that her mother will let her go with you to do these events. Although your family paid for it, her mom let her participate in those activities.
She would.
And that kept you all busy. Is that fair to say?
It did.
That's a lot of activities, right? Now, at some point, is it fair to say that your mom moved to Covington and you moved to Covington?
I did.
About how old were you when you moved to Covington?
13.
And Melissa would still visit you while you were in Covington.
She did.
And so her mother would let her leave from Stockbridge. Is that a yes?
McDonough.
From McDonough and come see you in Covington.
She would.
How far is that?
30 minutes.
So it's safe to say Melissa would have to come out of the room in order to come see you. Is that fair?
No, she didn't lock her in the room like at that age.
Okay. Now, when you all were younger, did you tell defense counsel that you all never knew what Carl Patton had done?
Never.
You did not know?
We didn't. Not until they came and got him.
And when you said when they came and got him, are you talking about you found out in 2003?
I'm talking not until the police came and got him.
Okay. Now, is it fair to say that the last time you saw Melissa was in 1997?
Last time I saw Melissa would be about 1998, 97.
97, 98. And I'm sorry, did your family have like an event every year and the
They did.
Pattons would attend?
Yes.
What type of event was that?
Holidays.
And you talked about Melissa's kind of demeanor. In your opinion of knowing Melissa, would she ever just leave her children?
No,
Would she ever just stop talking to her children?
no. Not that I'm aware of.
Now, when you spoke to Mr. McDermott, you described Melissa as not bright at times?
No.
No, you didn't, or no, she
Yes.
wasn't? I'm sorry.
Yes, she's not right.
Okay. That she was easy to control?
She was.
You said that she was weak?
She was.
You said that she was submissive?
She was.
You describe her as a type that would not fight,
She don't.
that she was very naive,
She was.
not a smart thinker. Mm-mm.
Not a smart thinker.
You said that she's dependent on whoever she is with,
That's right.
that she would not be the leader in a relationship.
She would be.
Matter of fact, in your friendship, she kind of follows you.
She did.
And you said kind of after you left, Melissa had no friends.
Right.
Now, I know you just told defense counsel that you never saw Mr. Wolfenbarger, but you had the occasion to speak to him one time on the phone.
Well, I guess very short, he would let me talk to Melissa.
Tell the jury about that.
He just wouldn't let me talk to her.
When was it?
In 97, 98.
Do you recall telling Mr. McDermott that was around Thanksgiving night?
It's earrings. It's earrings. Verification. Back up just 1 second. Watch her. She turns her head. She's got one on each side. It's earrings. Denise, you're right. Denise, call to order. Bang, bang. Everybody bang your gavel. Judgment's been made. Denise, we are right. It's earrings. She's got one on both sides.
98.
Do you recall telling Mr. McDermott that was
See that
around
head turn?
Thanksgiving in 1998?
Something like that.
And that you actually called to speak to Melissa on the phone?
I did.
And Chris answered the phone,
He did.
and he wouldn't let you speak to
He
her.
wouldn't.
And he was controlling her ability to talk to you.
He was.
And it's fair to say that at that call, he did not want Melissa to talk to one of her childhood friends.
Objection.
Sustained.
It's true.
When there's an objection and I sustain it, you have to not answer the question,
Sorry.
okay? Thank you.
And was that the only time that you talked to Chris in Thanksgiving of 1998?
Yes.
Court's indulgent.
Sure.
No further
Hey,
questions.
thank you. Mr. McDermott, any additional questions?
Yes, ma'am. You just told the state council that when you talked to me on the phone, you thought it was them.
I did.
Is that correct? And didn't I tell you on the phone, I'm Christopher's attorney?
Nope.
Uh,
He said defense.
Okay. Permission to play some audio.
I need to back that up a second. She said, no, you didn't tell me. Whose attorney did he say he
Didn't I
was?
tell you on the phone, I'm Christopher's attorney?
Nope.
Uh,
He said defense.
Okay.
Bitch, that's the
Permission
same
to play
thing.
some
Calm
audio, Your
down.
Honor.
She said you said defense.
Okay. So I did tell you.
Just making sure you heard her answer.
I did tell you I was the defense attorney.
You did.
Correct. And then I told you I'm Christopher's
You
attorney.
did tell me that
Okay. Thank you.
afterwards, yes.
At the very beginning of the conversation.
Look, I get high every day. I do drugs. So I'm just trying to tell you, I don't know, what I say. And I hate to burst your little bubble. I'm just telling you, like, I do heroin every day. And I'm going through withdrawals. And that's the whole point I didn't want to come here. So I don't know what this would be.
Were you on heroin when you talked to
I
me on the
was.
phone? You're on heroin right now?
Only because I'm locked up. Sweating to death.
just to reiterate, you quit hanging out with Melissa around age 13, correct?
I did.
So you had really not much interaction with her after that.
I didn't.
So you don't know what she was thinking or doing after that age.
No.
I'm glad it's not just me looking at this going, what the actual
No further
F
questions,
is
Your
going
Honor.
on
Thank
here?
you, Ms. Hilton. Anything else?
Brutal honesty. Brutal
In that
honesty.
Thanksgiving
from this
98
girl.
call that we just talked about, do you recall telling defense counsel that the Pattons were at your family's house for a family function? Is that a yes?
Yes.
And that it was during that family function you asked about
Her.
Melissa, and you said, "Give me a number so I can call her."
I did.
No further questions.
Mr. McDermott?
No further questions, Your Honor.
Okay. Ladies and gentlemen, just for some logistics, I'm going to have to ask you to step out for just a moment, and I'll be right back as quick as I can.
Yes, we have to let her walk away in her shackles without causing too much of a disturbance in the courtroom because they make a lot of jingly noise. And with that, we get the luxury of fast forward and we don't have to listen to her.
Will assist Ms. Waddell. She's excused as a witness. Thank you, Ms. Waddell.
Ms. Waddell. Waddell, yourself on out of here with your...
I was just going to say, I trust that her
Withdrawals.
release will be processed as quickly as possible.
Oh, they're going to release her now. Okay, so she can go get her heroin. Okay. Oh, Lord, guys.
So I understand what's going to happen when I call the jury back in. Does the defense have any other witnesses, or is the defense planning to rest?
Defense rest, Your Honor.
Okay, well, I'm going to need you to do it formally in front of the jury. I'm just asking in advance. Does the state still have planned rebuttal?
Yes, we have two witnesses for rebuttal.
Okay, and do you have them ready to go outside the door?
One is right outside the door, and the other is our DA investigator.
Okay, okay. Okay, so we're ready for the jury to come back in then, and we'll have the DA rest and, or excuse me, the state will rest and the DA
No.
can take up its rebuttal.
The defense will rest. Come on, Judge. Come on. The
Is that a
defense
yes,
will
Ms.
rest.
Hilton?
Yes.
Okay, is that a yes, Mr. McDermott?
I'm sorry, Your Honor. Question?
Okay.
Question again, please.
Are you ready for us to come in and proceed in the manner I indicated, which is that y'all are going to rest once the jury comes back in and the state's going to take up its rebuttal?
Yes, Your Honor.
Thank you.
Yes, and are we gonna get closings today? I don't know. I did not watch today. I'm telling y'all, I had doctor's appointments. I watched Journey during the day because she did Adelson. That was my place to sit today during all my crazy appointments. Yes, they're all nuts here. I sat with Journey and watched Adelson.
Witness.
Your Honor, the defense rests.
Thank you.
Rest.
Ms. Hilton, any rebuttal from the state?
Yes, Your Honor, briefly. The state will call Detective A.B. Calhoun.
Okay. If you'll coming up to the witness stand, and before you, once you get there, if you'll turn and face the deputy and raise your right hand, he'll swear you in.
You swear to affirm this testimony that you're about to give, truth, the whole truth, and nothing but the truth, so help you God. You should have a seat.
Just be careful of that ledge and then scoot up to the microphone and state and spell your name for the record, please, sir.
My name is Alton, middle initial B, Calhoun, A-L-T-O-N, again, B, C-A-L-H-O-U-N.
And good morning, Detective Calhoun. How are you?
I'm doing fine.
I want to direct.
Mr. Calhoun was day 3 state's witness. So they are bringing him back. So I guess we have more to discuss.
Direct your attention specifically to April 7th of 2003. Did you have the occasion on that day to speak with a Kimberly Cameron?
Yes, I did.
And how did you make contact with Ms. Cameron?
I made contact with her, phone contact with her.
And who, at the time, did you know who she was?
I knew that this was a very close friend, a very close friend of Melissa Wolfenbarger, and also Chris Wolfenbarger's sister.
And did you speak with her on that day over the telephone?
Yes, ma'am, I did.
And what, if any, let me ask you specifically, was she able to tell you about her relationship with Melissa?
Yes, ma'am.
And was she able to tell you about Melissa's feelings towards her brother?
She shared that, yes, she was.
What would she tell you?
She shared that they had problems as a couple, like everyone else. Sometimes they had problems.
Did Melissa ever tell you did Kimberly ever tell you if Melissa was planning on leaving her brother?
Yes, ma'am, she did.
What did she say?
She said that we were speaking, and she indicated that in a conversation that she had with Melissa, Melissa expressed her love for her brother, but while she loved her brother, that she was planning on leaving him. And
did Kimberly ever indicate that Melissa wrote her a letter?
Yes, ma'am, she did.
Did she still have the letter?
I don't know. I asked her about when we were doing the interview details if this was based on something from the letter, so I don't know where the letter may be.
And after speaking with her on the telephone, did you have the occasion to try to meet with her in person?
Yes, and I'll say that the telephone conversation was, the purpose of that was to set up a time that we could come meet, and I can interview her more in detail.
And did you eventually meet with her?
Yes, ma'am, I did.
And when did you meet with her?
Well, that was April 23rd.
And when you met with her, was there anyone else present with her?
Yes, ma'am, there was.
Who was present?
Her mother, Kathy Wolfenbarger.
And during that meeting, were you able to speak with Kimberly by herself?
No, ma'am.
Why not?
When I got there, of course, I met Kimberly, and I saw that Mrs. Wolfenbarger was there and learned who she was. And I told her that I would like to speak with Miss Kathy as well, but it was my intention to interview her, Kim, and then speak with her mother. And that I would like it. It'd be nice if her mother was to be able to leave, but Kathy made it very clear, I should say, that she was not going to leave. She was going to stay there with her daughter at the interview. So at that point, I had no other choice but to interview them together.
And where did you go to conduct the interview?
I went to Kim's home.
So this was at Kim's house?
This was at her house, yes, ma'am.
All right. I have no further questions.
Mr. McDermott?
Mr. Calhoun, you interviewed a lot of people during this investigation around that time, correct?
Yes, sir.
You interviewed Christopher, didn't you?
Yes, sir, I did.
And you remember making an audio
Yes.
Version of that interview?
Yes.
Do you remember interviewing Don Perone,
Yes.
the neighbor down the street?
Yes.
Do you remember Don telling you he drives a hearse?
Objection, hearsay.
Sustained.
You made an audio recording of that interview, correct?
Yes.
Okay. And you interviewed several other people. You made audio interviews of them.
Yes.
And we have something like 6 audio files that you created.
I'm not sure the number.
Does that sound roughly correct?
That sounds like that.
Okay. And for this discussion with Ms. Cameron, did you audio record that?
Which the initial phone interview?
The one you just testified about right here.
I believe I did. I'm not sure. All the interviews were there. If I recorded an interview, it was in the file, but there were some times where I just wrote things down from my notes.
So if there's no audio in the file, then you didn't do one?
There was no recorded interview. I just went on the notes from that interview. Yes, sir.
So what you testifying here today from the notes you wrote?
Excuse me?
Are you testifying here today from the notes you took on that interview?
Yes. And when I say notes, the notes that I did, the way it happened is, as investigators do, we have notes, a notepad, and you'll just write notes throughout, over the course of the investigation. I then at some time take those notes and transcribe those to the report.
Okay. Do you mind if I see your report?
Yes. Those would be the 2 pages from that time frame.
So those are not recording anyone's exact words, correct?
No, I just gave a brief synopsis. If you read these notes, you'll see this is just a synopsis of what they said to me.
Okay. And we have no way to check to verify if that's what she actually said.
What's that? Who's that? I'm not sure who you're talking
So you
about.
interviewed Kimberly, correct?
Yes,
And all we have from that interview is your written notes on it.
yes.
So we have no way to verify that that's what she actually said to you.
I guess that would be correct.
Okay. No further questions.
Ms. Hilton?
Did you have any reason to make up what your conversation was with Miss Kimberly Campbell?
No, ma'am. This was something that I had no reason to make anything up.
Thank you. No further questions.
Mr. McDermott?
No further questions.
Okay, thank you, sir. You may step down.
Thank you, ma'am.
Ms. Hilton, state may call its next witness.
Yes, Your Honor, the state calls Andre Curitan to the stand.
Thank you, sir. Will you do me a favor, come up to the witness stand. When you reach the witness stand before you have a seat, if you'll turn and face the deputy and raise your right hand, he'll swear you in. Yes?
I was getting excited. I thought we were going to get to know this man's name, but no. I heard his first name was Andre, but I didn't hear the last name. I was waiting to type. Okay.
Swear in the witness.
I
You
like
swear affirm to the testimony that you're about to give, truth, the whole truth, and nothing but the truth, so you may have a seat. Please state and spell your full name for the court, please.
First name is Andre, Andre. Last name is Curitan, Cureton.
And where do you work?
Fulton County District Attorney's Office.
And what do you do for the Fulton County District Attorney's Office?
I'm a senior investigator.
And just describe briefly some of your job duties as a senior investigator.
We mostly, we're assigned to attorneys, anything they need, any evidence to be picked up. We subpoena witnesses and sit with our attorneys as they interview the victims or witnesses.
And are you also required to sit in the trial of those attorneys as a trial may proceed?
Yes,
And have you been sitting in this courtroom for the duration of this trial as it's been proceeding?
yes,
Now, as a part of your responsibility, you said that you have to meet with witnesses with the attorneys.
yes,
Do you recall ever meeting with a Norma Patton?
yes,
Okay. And when you met with Norma Patton, do you recall her ever providing to the state letters and cards?
yes.
What did it happen with those letters and cards that she provided?
She provided to them. No, we made copies of them. When legal assistants made copies of them, so we can have.
And so did she bring originals the legal assistant will always make copies of those originals?
Yes,
And I'm going to show you what's been admitted as 67, 68, 69, 70, and 71. Are these some of the letters and cards that Ms. Patton provides that you make copies of?
yes. These are some of the ones she brought in.
And then we make copies of?
Yes.
Thank you. No further questions.
Mr. McDermott?
I have no questions for this witness, Your Honor.
Okay, thank you, sir. You may step down.
Thank you.
Ms. Hilton, state may call its next witness.
Your Honor, the state has no further witnesses. The state rests.
Mr. McDermott?
No further witnesses, Your Honor.
Okay. Okay, so that means the evidence in this case is closed. Ladies and gentlemen, there are a few things that we have to take up to get ready for closing arguments and the final jury instruction before you begin your deliberations. And so it's about 10:20. I'm going to excuse you. I'm guessing conservatively about 20 minutes. I'm hopeful that we'll be back in here around 11, just to give you a target for what to aim for. But for now, you are excused. We'll have you back as quick as possible. Thank you.
All right, for the hearing.
Okay. With that, we zoom.
You may be seated.
What are we going to talk about? Oh, y'all don't mute the mics now. We zoom in. Don't mute the mics. I need to know what we're talking about. Oh, she's on the side talking.
So we need to revisit some matters that we were dealing with yesterday in order to finalize jury charges. Are there any matters other than those? Are there any matters the parties want to bring to the court's attention that we need to address?
I don't think we have it.
No?
Nothing from the defense.
Okay.
I
So,
love it, Cindy. I love it.
let me, so I have sort of a bullet point list of things that I was supposed to do homework on last night. I have, and so let me address a couple of things. Number one, I have looked at the request from the defense to provide a charge on immunity of a witness. I think that the better course here is to not give it. It's not directly implicated by the facts of this case, and the defense doesn't need it to make the argument that it wants to make. And so I'm not going to give the immunity charge 13180. Mr. McDermott, you asked me to adjust the circumstantial evidence charge to change the word theory to the word hypothesis. I'm not going to do that. The pattern is the pattern, and I believe the pattern is there because theory is a more accessible plain language word than hypothesis is, and that's why it's been changed. And so we're going to stick with the pattern. Excuse me, sorry. I am.
Indy, thank you for being here, love. I appreciate any time you spend with
I'm not
us.
going to give the prior
You have a
difficulties
good rest of
charge.
your evening.
And that, as I consider it legally, I think there is a conflict in, I cannot find case law. And if you can point me to some, I would appreciate it. But I cannot find case law that distinguishes between the fact that prior difficulties, there's tons of case law that talks about the fact that prior difficulties are likely for intrinsic evidence, right? There's secondary sources and there's cases that say that prior difficulties is likely intrinsic, et cetera. But what I can't find is case law that reconciles this tension between the fact that if the court has ruled, which it has here, this evidence of the dealings between Mr. Wolfenbarger and the victim is intrinsic to the case, then I think that the evidentiary standard is very clear that that evidence can be considered for any purpose. And prior difficulties evidence would be the charge that's been requested by the defense is what would apply to evidence that wasn't otherwise intrinsic, but that was allowed as a prior difficulty. And because I've allowed it as right, wrong, or otherwise, because I've allowed it as intrinsic evidence, the jury can consider it for any purpose. And I think that instructing them on prior difficulty would confuse the jury about what the standard is that they are to apply. And so I'm not going to give it. The last issue is really two issues, which is I took under advisement the motion for directed verdict of acquittal on count 2 for felony murder, and obviously the associated jury charge that goes with that. If I grant the DV, then I wouldn't give those charges. I spent a good bit of time with this last night, and while I agree again with the state that there is evidence here from which either facts or reasonable inferences from which a reasonable finder of fact could determine that a homicide occurred and or that Mr. Wolfenbarger may have committed it, I do not believe that there are facts from which a reasonable fact finder could even make a reasonable inference that a weapon was used or what kind of weapon was used. And because of that, I don't believe that I don't believe that there are facts from which the state could present the count 2 felony murder, which requires that showing of aggravated assault. And so I'm going to grant the defense's motion for directed verdict on count 2 of the indictment for felony murder, which means that I would not give those charges. It means that the jury, I need to amend the verdict form to include the sole count of the indictment for murder. We also need a redacted indictment reflecting only that one count of felony murder. What record would anybody like to make regarding that ruling? Mr. Wilson, you're standing?
I would, Your Honor, and
Yes,
I'd like you to reconsider it in light of, I did look for some case law, and I thought what would be very helpful to everybody is case law where a murder occurred where either the body was never found or there was decomposition. They couldn't determine the exact cause of death based on advanced decomposition. And what I found was Richardson versus State, and the site on that is 278 Georgia 548, and it says that if there is evidence of an act, the jury can, and remember we're dealing with the standards for directed verdict, whether there's a reasonable path for a reasonable jury to follow the state of facts. And Your Honor, I do think that also on Courier versus State, which is the site is 294 GA 392. This was a case where there was, I mean, it's very similar to our case in that the remains of the victim were subject to decomposition, and the medical examiner gave an almost identical cause of death, which is undetermined homicidal violence. And that's what we had from Dr. Terry.
Right.
So what, and that was acceptable. And I believe, and that's actually a felony murder case, Your Honor, predicated on aggravated assault, where there was a non-specific form of aggravated assault. The court said that there had to be some evidence, and I'm going to get there really quick.
Mm-hmm.
Your Honor, and I do believe that the court has evidence, and the jury has evidence. As the court said before, the court was going to consider the prior acts of the defendant to the victim as intrinsic evidence. I think that's critical to the analysis on whether, and this is, like I said, this is a directed verdict standard. It is critical when the court makes that ruling that this jury can infer from the fact that he's done it to her in any indeterminate manner before, he'll do it to her, he could do it to her again. I think that's a completely reasonable assumption. And that's what the case law says. They can consider it for any purpose that they choose, Your Honor. So I think that because it's intrinsic evidence that there has been past domestic violence, you've got that. That's the big thing. You've also got the medical examiner saying undetermined homicidal violence. You've also got Rosa James saying, educating the jury on the cycle of violence and what happens. Your Honor, there is a path, and I understand where the court was coming from. But I think when you allow intrinsic evidence that can be used for any purpose, that's what the question is on a directed verdict. It's not whether or not it has to happen, whether it's possible that it could happen. And I think a jury can take that evidence of the prior assault and say, you know what? Given the escalating type of violence, this is now an aggravated assault. And this is why she died. And that would bring it in directly with the case law. So that's our argument. Your Honor, I think the court should reconsider its motion, or its ruling on the motion, and allow this case to go to the jury, because I think there is evidence. And I know the court was struggling with that extra evidence, but it's there.
A couple of questions. One, I was able to pull up the Courier case.
Mm-hmm.
I'm not, the first case you gave me, I don't know if I've typed it in wrong or wrote it down wrong. Can you give me that site again?
Sure can. It's 276.
Wait, say it again?
276.
276.
That's what I think we all wrote down. 270.
You said 278 because I looked up case law 278. You said it wrong. Okay.
The 8, or at least that's what I wrote down. 276 Georgia 548.
Yes, ma'am.
Yeah.
Thank you.
See, okay. Thank you. That'll fix it.
I will tell you, one of the reasons that I wanted to make sure I had the right citation for that case is that my brief review of the Courier versus State case is it would be distinguishable because I think in that case there was direct evidence of some sort of scuffle between the alleged perpetrator and the victim prior to the victim then later being found dismembered and in a decomposed state, which is evidence from which a jury could find that aggravated assault of which there was evidence caused the death. I mean, I read that case very briefly to be more about proximate causation than about whether there was evidence of an aggravated assault, because it sounds like there was.
Well, and I think when you, like I said, when you allow intrinsic evidence, is there a path? That's the thing. Is there a path for a reasonable jury to conclude that the violence escalated and this defendant committed an aggravated assault? I think it's relatively settled that the manner of aggravated assault is not really the relevant factor. It's is there evidence? And I think Richardson talks at that, and I think Currier does too. But I think with the intrinsic evidence of past violence and the fact that the jury can consider that for any purpose they want to, and given the standards on a directed verdict, could they do it? Absolutely, Your Honor. That's our position. So I'd ask that you reconsider.
Okay. I appreciate that argument. First paragraph of Richardson says that there were bloodstains found on the victim's bedroom ceiling and walls that were evidence of the infliction of severe blunt force trauma. That's, again, factual evidence from which a jury could make a reasonable inference. What we have here is a history, right, between the defendant and the victim, but no direct evidence of a particular interaction between the two of them that could constitute an aggravated assault. And more specifically, there's no evidence from which a jury could infer the presence of an dangerous instrumentality or offensive weapon. And that's really, to me, the deciding reason. I understand the state's theory, but I still don't think that there are facts or reasonable inferences that can be drawn from those facts, from which a jury would be justified in determining that an offensive weapon existed and or that an aggravated assault occurred. There is evidence from which a jury could infer and determine that a homicide occurred. And so that's why I've ruled the way I have. I understand the state's objection. Is there any further record that you would like to make on that point, Mr. Wilson?
I don't believe so, Your Honor.
Okay, thank you.
Your Honor, I'd also point out that Richardson's a malice murder case. It's exactly what you're holding in this case. There's sufficient evidence for malice murder.
Okay. Anything from the defense? Okay. So it is 10:40. What I need to do is I'm going to, as I said, edit the verdict form. I'm going to email y'all in just a moment. I'll probably have my staff print a final, or more final, unless y'all tell me there's something else to address, version of the jury charges. Is the state in a position, because y'all have, my understanding is it's easier for y'all to
I love you.
print a version that's whited out of this. I can have my staff get rid of count 2 in both places if you want me to, but since the indictment goes back with the jury, they need a clean version of it, which is that one count. Okay? Okay. It is 10:40. My goal is to be back in here at 11 with everyone's final approval of the verdict form and the jury charge, and then ready to start with closing arguments.
Are you taking it now?
Is that good with everybody? Mr. Fawcett?
Yes, sir.
Mr. McDermott?
Yes, Your Honor.
Okay, we're in recess until 11.
Okay, with that, we're gonna zoom. I'm sorry. He brings me. It's a sleep mask to put on for me to sleep. I don't know. He just handed it to me. I guess he thinks I'm gonna take a nap. I don't know. That's my Hector. I never know with him. Okay, so we're gonna get straight into closing. Okay, ready? Oh, y'all, it's always a wild ride in my house. You just never know what's gonna happen. I mean, the dogs were out today. We weren't even home. We had doctors. I mean, it's just
And
then Meat knocked a hole in 3 pickets in the fence. Just totally knocked the fence out. 3 pickets, just bam, gone. Hey, Ada, how are you? yeah, so Meat knocked out the fence. I mean, I've got 3 pickets that are busted, but he came home. We got him. So it's all good. All right. So we zoomed, guys. We're on to the fixture.
Okay.
Closing.
Okay. Madam Court Reporter, you ready?
Yes.
Okay, so Mr. Wolfenbarger is back in the room. I have provided the lawyers with a newer version of the verdict form that is only count 1 for murder. The state has provided me and Mr. McDermott has had an opportunity to review a redacted version of the indictment that only charges the 1 count of murder. I've also provided the lawyers with the jury charges that I have redacted and tailored further to the evidence in this case to remove references to the 2nd count of the indictment and to remove, for example, like I usually have a pattern that says, there's a multi-count indictment, so I've removed that. And wait, I just realized I missed one. I need to remove prior difficulties, which I advised the parties I would not be giving. So if y'all could please make a note, I'm removing it from the version that's going to go to the jury and I'm removing it from the PowerPoint that will be displayed. But if y'all could please mark that out in your packets.
Y'all know I don't do silence.
Indicated I would not give it. I believe that now that I have removed the prior difficulties charges, I indicated I would not give it. I believe that the version that I have provided you accurately reflects the rulings that the court has made in terms of what the court intends to give or not. If you've had a chance to look at it, any objections to the charge that the court intends to give from the state?
No, yeah.
Mr. McDermott for Mr. Samuel from the defense?
Well, we wanted prior difficulties.
Yes, sir.
We wanted 404B.
Yes, sir.
Do you need us to renew our objections after the charge, or is this the only time to preserve?
So what I was expecting, other than preserving the objections you've already made,
Right.
Do you have any additional objections to the charge that the court intends to give?
No.
Okay. And then after I give it, I will give you an opportunity to say that you object to the charge as I gave it.
Right.
Okay. And then the verdict form, which is just the 1 count. Does anybody have any objection to the verdict form?
No, yeah.
Okay. So what I'm going to do in just a moment then is bring the jury in. And just so you know, I will provide the jury with a copy of 1 copy of the jury charge, the verdict form, and the redacted indictment. That will go on top of whatever evidence the parties agree is going back with the jury, subject to any continuing witness or other objections the parties may have. I know we have one, just to flag it for everybody's memory, Exhibit 30A is a redacted version of I think, audio recording, and we're in agreement that 30 is in evidence but would not go back. It's 30A that would be played for the jury if they wish to see it. Beyond that, I will rely on the lawyers to tell me if there's any additional evidence that is in evidence but should not go back with the jury. Anything else before I call the jury and then we get started with closings? From the state?
No, Your Honor.
From the defense?
No, Your Honor.
Okay. Do you have a PowerPoint?
I do.
Okay. Are you logged in and ready to go with it?
I am.
Okay. You can go ahead since I'm going to go straight into, well, I take that back. Are you going to open and close, Mr. Fawcett?
No, just to open.
Is the state going to open and
I'll
close?
start it out.
Right. Okay, so since the state is going to open and close, you can go ahead and have your PowerPoint up and ready to go on the screen. We're ready for the jury.
What time do you plan to take a break?
I've ordered lunch for the jurors at 1:30, and so my plan is to see if we can target being done at 1:30 or shortly before, but if we can't, then we'll keep going unless the jury says they need a break.
It was a lot to deal with. It really was. Well, thank you, hon. Thank you. I appreciate that. All right. So y'all know me, Zoom. We don't do all this quietness and silence breaks. Speed trials.
go out, if you'll please do so as quietly and non-disruptively as possible. Thank you.
Okay. Standing for the jury.
Ladies and gentlemen, I'm now going to allow the parties, the state specifically, to make its closing argument.
Thank you. So what's being depicted now is one of the first exhibits that we introduced. That is a photograph of Melissa John Wolfenbarger. And that's a photograph that was taken somewhere around 1997, a year before Melissa went missing. In 1998. We know that in 1998 she was 21 years of age. So she's roughly about 20 years old at that point. And even though she hadn't gotten a chance to live a very long life, she was a mother at that point. She was a wife. And when I look at it, when I see that photograph, I see a smile, but I also see hope. I see hope when I look at that photograph because of what she must have thought about her children, what she hoped for them, the life that she hoped to live. And I think about the 27 years that has passed and how long that is to wait for justice. But that 27 years, that's a long time to experience life. That's a long time to fall down and get up, and fall down and get up. That's time to experience and have memories with your children. Children that don't have a memory of Melissa. Not Joseph, not Christina. That's an opportunity to have and create memories with your grandchildren. I have 3 grandchildren that you heard Christina testify. She's got 3 boys. It's opportunities. That's what was missing. That's what has been missed. That is what has been taken away from Melissa. The opportunity to have a life, to have those experiences. And she deserved that, even if she didn't want to spend it with this defendant. Even if she wanted to leave him, she still deserved to have that opportunity. She was manipulated. She was intimidated. She was abused. And she was coerced to give up her children. I believe that's what the evidence shows. And I can tell you, 27 years later, I would not expect a judge to allow a defendant that battered his wife to be alone with them, to speak to them 6 days after it happened. Roughly 5 or 6 days after they went down to apply for a protective order. 5 to 6 days after the order had no contract was in place, the judge lets her speak alone with him. And then on that very same day, I want to dismiss. On that very same day, children go back with mom. And we don't know what was said. We don't know what was said then. We don't know what he said to them. We don't even know if the bruises that were on her from his attack on July 21st, 1990, we don't even know if those are fully healed yet. I can assure you the mental and emotional trauma from that act. Having to call the police after a period of time in July where we know she had already been abused and experienced abuse. So when we think about domestic violence and we think about being intimidated and coerced, that's what I want you to think about when we look back at that date, July 29th. I believe the evidence shows that she was intimidated. She was able to be in focus, especially after being beaten for a year by this defendant. And I don't believe that she ever intended to give up her children and walk away from her family and her children.
Your Honor, I want to object to counsel's repeated use of "I believe." I can assure you, counsel is not supposed to interject personal opinion.
Understood. Mr. Fawcett has offered to rephrase. Go ahead.
Now, the indictment you'll get will have one count of murder, for the malice murder, the intent to kill, the intention to kill Melissa Walkenbarger. And this is why we're here, from what was found on April 29th, 1999, and June 3rd, 1999. Skull of Melissa Walkenbarger, in his job, communities within that same vicinity in the wooded area. In a minute from the residence where Christopher Wolfenbarger and Melissa Walkenbarger lived. And your judge is going to instruct you that you are duty bound to follow the law. And in your consideration of the law, you should consider certain things and certain things you should not consider, such as sympathy for either the victim in this case or the defendant, disagreement with the law, conjecture, dislike of the system, television, public opinion, penalty or punishment. The only thing that you are to decide when you're considering the evidence is whether or not the state has met its burden beyond a reasonable doubt and prove a guilt for innocence of the guilt of this defendant. You should consider the elements of the crime, the law, which the judge will give you. The oath that you've taken as jurors, facts, the case as presented in the form of testimony, video exhibits such as.
Now I'm all for a slideshow, but I'm not following this one. I'm sorry. I'm just being honest.
The video of the defendant hiding. Audio exhibits such as the audio of the defendant stating that you have to look for. Acknowledging that he took assault. Also acknowledging that she was dating someone and seeing someone and staying with someone named Mike. She also considered the credibility of the witnesses. What was it like when they were testifying? How did they answer the questions? You are entitled, you're the determinant of the credibility of not just the state's witnesses, but also the witnesses that the defendant called. You all consider what the defense is. Now, the defendant doesn't have to present any defense. Walk into court Tuesday, Wednesday, say, hey, make an improvement. But that's not what happened in this case. The defense in this case is Carl Patton. Listen to the theory, the opening statement. The defense in this case is Carl Patton killed Melissa Walkenbarger. Other than the fact that evidence came in that Carl Patton committed murders, what other piece of evidence or fact, anything that you heard during the course of this week, what points to that? What other fact would allow you to create that evidence? Other than the fact that he killed someone, the evidence came in, Melissa didn't even know about it. The only thing that's come in about the relationship between the Pattons and their children is that they appear to love each other. It's not so unbelievable. Based off of the letters that Melissa wrote, cards that she wrote, times that she wanted to take her father, Carl, and her mother, Norma, out to lunch. Those are going to be back in the room with you for you to observe and look at why you deliberate. This case is just simply not about Carl Patton as much as they want it to be. This case is about domestic violence. This case is about intimidation. This case is about loss of control. The loss of control that this defendant had over the custody of his children and over Melissa. No matter how much they want this case to be about Carl Patton, this case has nothing to do with Carl Patton, other than the fact that he asked law enforcement to find his daughter. Why does Norma go to the residence of Kathy Wolfenbarger looking for Melissa, raising attention to that issue if they're responsible for it? Now, a lot of facts have come to evidence in this case. I would ask you to put weight on more the facts that have been corroborated, like that. You heard that from Norma. You don't have to just take Norma's word for it because you heard that from Christina. She does not have a lot of memory from her childhood. She doesn't have a memory of her mother, but she remembers that day. Because that stood out at her. Where is my daughter? I could just imagine how that was. It wasn't a calm statement. It was screaming, where's my daughter? Norma probably showed up to that residence, Kathy, in a panic. Where's my daughter? That's something that Christina would remember. And that's why you should believe that happened. And that's why that theory is just plain ridiculous. He killed Melissa Wafler. Most importantly, your common sense is the main thing to grasp and to use and decide in this case. What does the evidence tell you? What does the facts tell you? What is been presented? Judge is also going to charge you on what reasonable doubt is and what it is. Judge is going to charge you that the state is not required to prove the doubt or the guilt of the defendant beyond all doubt or for mathematical certainty. Reasonable doubt is a doubt of a fair-minded, impartial juror, honestly seeking the truth. Is a doubt based on common sense and reason. It does not mean a vague or arbitrary doubt, like Carl Patton. They arbitrary, not supported by the facts, thrown out, hoping to stick on the wall. Evidence may be direct or circumstantial, or both. Consider the evidence. You may use your reasoning and common sense to make deductions and reach conclusions. May be direct or circumstantial. Direct evidence is that which may be seen or heard. Otherwise, direct sense. So when Christina says, I saw Norma show up to the residence in a panic looking for her daughter, that's direct evidence of her observations. And from that recollection, the testimony of Norma, you can infer that Norma was sincere when she was looking for her daughter. The types of inferences that you can infer from the facts that have been presented. And then we have the circumstantial evidence. This is exactly what I was referring to. We got direct evidence of tool marks on bones that were recovered and identified as the remains of Melissa Wolfenbarger. Tool marks are direct evidence. Those observations, you'll have those that you will be able to review and look at while you deliberate. You also have direct evidence that the defendant was in possession of assault. Two separate facts. Now you wouldn't, and we wouldn't walk into court on Wednesday and ask you to convict because there are tool marks on the bones and remains of Melissa Wolfenbarger. And we wouldn't ask you to walk in here on Wednesday when we start presenting evidence to convict this defendant of murder because he was in possession of assault. And you draw logical, common sense conclusions from that. That's just one piece of the evidence that has been presented, which you were able to do that. We had saw around the same time that the wife was missing, was wife's remains were located. The medical examiner says there's the saw that we presented is Exhibit 66 is consistent with the type of marks that would be made by that instrument. And in his own statement that he was in possession of it around that time, and then the statement of the rocks, although they were reluctant to say so, that they never got that saw back. We would not ask you to convict solely based on that fact alone, but that is a fact that you can consider, and those are inferences that you can draw. Reasonable, common sense inferences. So this is what I saw when I woke up this morning. I probably see this a lot more than most people, but when I woke up, this is what I saw. And I had time, so I stopped by to get some gas. And by the time I finished, I got back and I crunked up the car, and I'm back on full. So I never saw anything go into my vehicle, but during that period, I smelled what appeared to be gas because I'm cutting grass. I smelled gas. there's about, there's less money in my account. The numbers on the dial are money. I hear a clicking sound. And so, even though I never saw any gas on my vehicle, there are logical deductive conclusions that I've drawn from all those facts and circumstances. Nobody's going to be able to come and tell me that Santa Claus put gas in the vehicle. So when we ask you to use your common sense and look at the facts, the evidence is what it says it is. The facts are what they are. In the count of murder, you'll get the indictment. You'll see that it's charged that the defendant with malice toward cause and cause the death of Melissa Wolfenbarger by inflicting homicidal violence. Now, as it's charged, that term homicidal violence, based on the manner in which the remains were recovered, it is impossible for the medical examiners to determine if she was shot, if she was strangled, if she was stabbed, any number of ways that you can commit a murder could have been committed to Melissa Wolfenbarger. But you can't tell if someone has been strangled if their neck is missing. You can't tell if they're stabbed or shot in their torso if there's no torso. And what we're able to determine based on the testimony of the medical examiner is that the facts and circumstances what she observed is how the remains were located, the history and evidence of domestic violence in that relationship, the fact that there's evidence that someone removed her limbs with assault. All of those facts, and the fact you heard her testify that in her medical examiner, she did not believe that Melissa Wolfenbarger died of natural causes. All those are facts that point to homicidal violence. In her opinion, was that it was more likely that Melissa Wolfenbarger died from homicide. That was her opinion. And that's why the indictment is charged like that, is because of how she was found. But that does not take away from what we have proven based on the testimony. And that is that she died from being murdered. That is called homicide. Just going to charge you with the law of malice. It does not deal with a hatred. It is just simply a killing without justification, excuse, or mitigation. It can be expressed, deliberate intention to unlawfully take a life of another person, and it may be implied with no considerable provocation appears in all the circumstances of the killing show and abandoned in the living heart. I submit to you the facts and the circumstances of this case, and all the facts and circumstances of this case point to that conclusion as the only reasonable conclusion, that this defendant did in fact commit malice murder on the person of Melissa Wolfenbarger. The state does not have to prove premeditation to prove murder, regardless of how briefly that malicious intent existed. Malice may be formed in an instant. And if malice was in the defendant's mind at the time of the killing or act and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive is for use in determining the defendant's state of mind at the time of killing. You are allowed to consider it, such as the evidence of domestic violence is lawful evidence of motive. Did he abuse her that year? Did he hit her? Did that happen multiple times that year? That's what the facts have shown. You can use that and those facts and the expert testimony from the domestic violence experts as evidence of the defendant's motive. And all of those things I previously mentioned, the fact that there's an open criminal case that she wasn't able to appear to. The fact that she was seeing someone else. The fact that she planned on leaving, that she had continually left him throughout that year. All of that is evidence of motive. Judge is also going to tell you that the testimony of a single witness if believed is sufficient to establish a fact. There's no legal requirement of corroboration of the witness, provided you find the evidence to be sufficient. That means if, when you heard the testimony of Christina and you believed it, you don't need any corroboration for that to be a fact that you consider. That means if you heard the testimony of Christina and you believed her when she said that this defendant would always talk about going on a run. When you talk about, you know how to get rid of the Bible, it says that to his daughter, considering how her mother was found. That's after she says that after Melissa Wolfenbarger's remains have been identified. He makes those statements. That's what she remembers growing up. Does that? This defendant. This case went through several detectives that basically continued to work on this case. Detective Calhoun and Detective Shepard. Even through the retirement of Detective Calhoun, he continued to work with Detective Shepard until the cold case unit was created, and then 3 years later you have this indictment. So from Detective Kelly, when we're talking about this skull is found, to the point where Norma Patton goes to Henry County, and Detective Stott really is the first investigator that starts to really investigate and look for Melissa as a missing person in Henry County. He wasn't able to get a lot of traction with the Atlanta Police Department at that point in '99. We have Detective Stott, who interviews the defendant. Back during that period, it's before 2003, he says, March, April, '99, last time he saw her alive. You have Detective Calhoun being assigned the case in 2003 when her remains are identified. And then when he retires, you have Detective Shepard, and he works with Stein to do some additional testing. And Detective Stein testified that he was one of the first persons to begin the missing persons investigation. And that's when the defendant, when we interviewed, told him that the last time he saw Melissa was in March of '99. And we know that from the subsequent statement in 2021, when he met with Detective Shepard, that's not exactly what he said. He says it was around December of 1998. The only difference between when he makes that statement before 2003, that he saw her in '99 of March, and in 2021 is Melissa's remains have been identified. We know that the remains
That's
were
them on the
located
volume. They
right
muted
by
it.
his job.
I
And
can't do anything.
I submit to you that there's a reason why those two statements are inconsistent. That's his line.
Okay, this is frustrating. Why do courts
If
allow
Calhoun
this to
spoke to the
happen
defendant,
full time?
once the
They
remains were
need
identified, the defendant, once the remains were identified,
full-time audio visual in
and
all
also
courts. This is just my
began to look
opinion.
into the history. Because the first thing they do with
Horrible.
homicide investigations, they look at
We
what
cannot
was the
hear.
victim's life like.
I want to scream.
First thing he saw was there's evidence of domestic violence. What stood out is the location. You know that in this area,
This is not
action
fair
last.
to us.
The extremities are virtually right next door to Action Glass in this wooded area. So, make no mistake, everyone's a suspect, but at this point, all of the evidence is pointing in this
And there
direction.
went the sound again, just as I made a comment.
What is this case?
They fixed it.
China Patton said somewhere around the
And
end
he's
of
just
97.
still.
Sometimes on the same scene, marks around the neck of Melissa Wolfenbarger. What she described appeared to show that
Y'all, it was me.
marks.
Y'all know what I did? Y'all know what I did?
sometimes on the same shift at the beginning of '98. There was one point when Tyner remembered seeing marks around the neck of Melissa Wolfenbarger. What she described appeared to show that marks of someone's hand around Melissa's neck. Immediately, the officer's defendant went out to confront her. And that's when he got into the altercation with Troy Clinton. That's what you heard in the testimony team. And that's the beginning of 1998. And we get to July of '98. And so this is what Detective Calhoun is looking at as he's beginning to investigate the case. He's looking at the location of the remains and where he lived at, his job, and he's looking at all this information. All the evidence is pointing at this defendant. There's a police report that's created where the officer observes bruising and marks on the person, Ms. Wolfenbarger, Melissa. After that, he directs her, the defendant isn't there. He doesn't wait around. After that, he directs her to go for him, take out a protective order, get you some protection from him. And that's exactly what she did. She went down there in person and applied for a protective order. So those are the records that Detective Calhoun had access to. This is the day after that July incident, July 21st. So the next day, July 22nd, she goes to the courthouse and petitioner seeking relief from family violence. From him. That's who she was seeking relief from. She was seeking relief from the choking that she had and her sister observed, that Troy fought him about. And we had that Rule 9 side setting it down for the 29th, and then we have that where the judge allows her to speak with this defendant. Just days after that. Days after her hair is being dragged and pulled. Days after she's been hit. And then that happens. It wasn't just what Tyner said. It wasn't just what Marlon Sutton said about what he observed. There's another person who saw that abuse. Dorothy. Jones, Cooley Jones. Dorothy Cooley. She lived in that area. She'd known the defendant before she met Melissa. And remember seeing a day where Melissa had shades on and a black eye. When we talk about testimony of the domestic violence expert about humiliation, isn't that humiliating? Walking around and get another bruise, another mark, another scratch. Sitting up here talking about skin conditions. That's not a skin condition, that's a black eye. You should be offended by them talking about skin conditions and kind of pawn that off as reasons why people saw marks on her. Tina didn't see a skin condition. These marks from this defendant's hand around her neck, that wasn't a skin condition. That was bruising for being choked. The black eye was in a skin condition. He punched her in the eye. It's not a skin condition. Thomas Dixon. All the witness statements line up perfectly on top of each other. The witnesses that observed the abuse during the shoot. This is at the interview. So we go from 10 at the beginning of 1998. We go from Dorothy. We go to July, Officer Sutton. Then we get to the end of '98, and she's still being abused because she's still going back and forth between Dixon and this defendant. She's still talking about the abuse. This is at the end of the year. Last time he sees her is in December. She's being whooped, intimidated, coerced, bruised, punched, dragged down the street the entire year of 98. And I see that's not the first year it started. It didn't just start in 98. Even further, this has been going on for a while. Not just 98. Dixon confronted the defendant after he came to the Waffle House at the end of that year. You gotta leave. You gotta go. What did Dixon see? Them talking, Melissa crying. Kind of like that July 29th day at the courthouse. Them talking, Melissa crying. Then we got investigator over here. You heard testimony that from the mother. The DA's office went to interview the defendant's sister a year before that happened. He knew from that the DA's office was still conducting an active investigation into the death, murder, disappearance of his missing, murdered wife. So make no mistake about it. That had already happened the year before. He knows exactly why the police are at the front of his house. Oh shit, it's his fan. He's hiding for 30, 40 minutes. Come out. He's right here. Let's see the video. There he is. Come on out, buddy. Gig is up.
Yeah, 27 years. What's up?
Y'all know I never try to interrupt, but goodness, yes, content creator had better audio than what this court is doing, and all the back and forth with when they go to this slideshow that they're doing, the freaking sound just goes haywire. I'm just like, no, I mean, my mic is a $20 mic off Amazon, y'all, and it picks up every noise in this house. If I have to be careful. So, I mean, why? I don't understand why courts cannot fix this. But what I was going to say before I got sidetracked, squirrel, he was hiding. If y'all remember the video, he was hiding under the little wine shelf thingy, that they had to go dig him out of. He showed so much guilt in his actions is what I really want to point out. He showed very probable guilt with his actions, in my opinion. And again, I've always said everybody's more than welcome to their opinions. I'm all for it. But, and we can always agree to disagree, but I'm having a really hard time finding how the jury's going to put all this together and be able to find him guilty. I'm having a hard problem with it. So with that, let's hit play again.
And doesn't it look like what you saw? Doesn't it look like it was planned? It didn't look like it was his own.
It looks like he planned to go there. Got there real quick, went out there, and sat out there for, I don't know, 10, 15 minutes. Police! Go hide. Guilty. Detective Shepard. He picked up this investigation. Had those same suspicions. Got home, had all the evidence is pointing to this defendant. But I'm going to interview Chris. See what he has to say. Let's see if his statements are consistent. Well, he admits to being fired because the Brock thought he stole the salt. Well, that's interesting. Admitted that he borrowed it. That's interesting. He admitted that him and Melissa were having problems. Admitted that Melissa was seeing and staying with a guy named Mike. admitted that he did not look for his wife. Well, here's the thing. Even if, he still has 2 young children. Very young children. Even if him and Melissa had planned on going their separate ways, wouldn't you think that at some point he'd want to be able to tell his children he looked for their mother? Wouldn't you think that? Wouldn't you think at some point, for his children's sake, he would try to look for their mother? That is a fact I think you should consider, because you look at all those pictures of Six Flags. What is he trying to say? He's a good father? No, he's not. He look for their mother.
You can take your kids to Six Flags every day. That does not take away from the fact that you didn't do what you were supposed to do. One, you shouldn't have abused her. You should have
Intimidated her. You shouldn't have punched her. You shouldn't have grabbed her hair and dragged her. You shouldn't have murdered her. That's not a good father. And then you had that statement that he made, the detective, Detective Shepard, and I want you to hear this. So I'm going to take a moment and play it. I want you to hear this, what he says, those points in particular, what he says about the assault, what he says about his efforts to look for his wife, and what he says about his knowledge that she was going to leave him, the problems that they were having, and the knowledge that she had about Mr. Dixon.
Battery 60%. Connected to PHEPL 549022HEC and PHEPL 540039F10.
I mean, before that, where was she working? At that time, the Waffle House, I mean, like, she worked 1,000 and no, she wanted to that. Where did she work? At the glass company around the corner.
All right, so when was the last time you saw Melissa?
And that's the thing, you know, I don't quite remember what the last time was, because I remember, like, she would come and go, okay? And we'll say that it wasn't like, we're happy-go-lucky, she's sitting right here one day and she was up and gone. And I don't know if that's the way.
So would you describe your relationship as tumultuous or like on again, off again? You know,
it was rocky there towards the end, mainly I think because it was her family so far trying to get back in her head and trying to make her think things and do things. And
like what?
Man, she never had a relationship with her sister at all. You know, and then there towards the end, you know, I guess everybody has a need for one, you know, family, wants to love and want that type of thing. You know, and I think there towards the end, maybe she tried a little to try to get back with him or to do or what. But I don't think it was near what they made it seem like, that she was there all the time, or she lived in cars and pictures. And I know that did happen sometimes when she did, you know, at that time. But the struggle that we had, we had a common goal of what we were trying to accomplish. You know, we had several adults in our,
Which was to go to California.
this is a good way to get that and all. She was like, I'm with my mom. She didn't want more than that. She didn't want her to be raised like she was being out there. There was no, you know, we knew that her hands were bad and anybody could go out there and do.
Okay, so when was the last time you saw her?
But the last actual time I remember was like, I woke up and she was gone. Like, we were in the middle of the night and she was left. And I don't know if that was the last time or the last time when I dropped her off the train station to go to work. If it was exact. I don't
Do you remember telling Detective Calhoun that the last time you saw her, you were driving up to your house on Brookline and saw her walking down the street. And that was the last time that you saw her.
I don't know what they're saying now, but it's possible.
Okay.
I just don't.
So that, basically, you said that was the last time you saw her, that she said she was going to the train station. Something to that effect. I'm not saying verbatim that's what you said, but it was something along those lines.
It's possible. I'll give you that.
But does that sound like it's accurate?
Again, it could be. I don't know.
But you remember that incident, or can you recall that happening almost about to be home, driving up and her walking down the road? Does that ring any bells?
I mean, that's usually the way it happens because we only have one way. You know, if there
She
was,
would walk to the train station, try to go to work or something.
or I get a ride, or she, you know, sometimes she just wanted to walk. You know? Like, and we're not talking about like crazy from far away, we're talking about the here right at the end of the road.
Right. Yeah, I know. It's in the city, so I understand. But talking about that specifically, do you remember that day specifically?
I don't know.
Did you remember?
One is that road.
Well, I would like to ask you, what was she wearing? Do you remember? Did she have a purse with her? You know? You know, the last time you saw her, when you came back home, she wasn't there. Where was her stuff? She didn't have a car. She couldn't move it, so it was still there in the house.
I mean, if she left or just like that, it was only like just small. I mean, kind of the same thing I did. I mean, when Austin drivers moved, when they're going to sell the house and everything, you know, when I left, I didn't take part of them. I don't live alone. So whatever.
After the last time you saw her, or that when she left, did she tell her family? Did she tell your family? Did you tell her that your wife left?
I mean, she had left many times before that. When she would leave and go, I never knew that was the last time I was going to see her. If I did, I would have, you know, freaking kept her.
After that, like a month or two, you think that was?
You know, after a while, I was saying that she was split and moved on. I mean, there was, you know, she was maybe seeing the guy and everything that was up there, or I know that she was living with in Buford, or no, I can't remember the last one was Buford or Peachtree Corners.
Was she seeing somebody?
I don't know if she was seeing somebody, but there was this dude, and I want to say his girlfriend, that sometimes that she would stay with him in like an economy lodge out that way. And
She knows his people.
she worked with him.
Or the girl, or the guy?
I want to say the guy and the girl both worked there, but I could be wrong. I know the guy worked there, but I know that it was a couple, you know, because then there was this one time that they had called me and said that they were moving and she had to go and do something. You know, she had to do something else.
And this was before the last time you saw her, right?
Well, that's
That's what I'm saying. I'm just wondering.
all that was.
I'm not misunderstanding you.
Right.
I'm not trying to trick you or confuse you.
No,
I just want you to remember.
I'm trying to figure it all out.
Like, if you were there, I was, so that's why. If I'm terrified, I don't know. I just want you to be accurate. All right, so year goes by, you still don't tell anybody that she's gone.
I mean, I'm figuring that she's already done. I mean, we were always talking about changing it and doing all, and she had the stuff there.
Right.
You know, and she got to the point where she was happy, unhappy with me. I'm not trying to push myself in anybody's life that doesn't want me there. I mean, I look at my daughter, and everything was going there. I've been trying to push. And, you know, looking back at everything now, I was wrong. All the way around with both of them. Maybe I should try to push forward and try to do it, but
You said you lost your job back then. Your job, the last time you wanted to leave your job.
man, this guy, now, there's a lot of things going on right there with that. But, and I do now the same thing pretty much I did then. I mean, I work on local players and things on the side. And there was a guy that I wasn't stole things. There was a saw that was missing. And I can tell you the exact guy that I borrowed this tool from and everything to, I didn't steal that saw. Period.
Why did I?
because he said I stole something, because if I was missing, and I live around the corner, and he goes.
Wait, no, I need to know who this is a recording. This is not making any sense to me because now whoever this is talking about stealing a saw. So are they going back to the Thomas guy that was he dated her, behind the scenes? That Thomas Nixon, he worked with her. I'm so confused. They didn't make this very clear.
That's my house, and you see the back of the book player, I heard copies and stuff.
So he thought because you cut something off the car.
And I flat out said, look, I don't know anything about it. And then there was that, and then there was something where I drove through the toll plaza thing on 400. There was just a bunch of little things that was just last
I
right.
knew you could go through the toll plaza.
There used to be a thing where you could go through it.
Right.
And I was under the understanding, I was under the understanding that, there's a thing of painful, or just a bunch of little things. And that was just like, there was no big deal, there was no,
It's what you go.
right,
They filed and so
And what we had to do it, and if that was there, where I bought it, I tried to tell them whatever, but I said the last straw I did.
Did you ever go up to the Waffle House and get an altercation in the mail?
I don't remember, I saw that on the internet, I don't remember that.
Guys who came up there and beat you up.
And it seems like I would remember that, but I don't,
You drive a yellow Volkswagen?
I never had yellow, no. What?
It's never yellow.
Never, I've never had yellow. I had a thing against yellow cars.
What do you think happened to it?
Man, here's which way I think about it. It has to go back. If her parents didn't do it directly, it had to be something indirectly around. I agree with her.
So when you found out that a body was found just around the corner from where you were, and the body.
Okay, he's saying something about if her okay, I gotta rewind it.
Body has been dismembered with a saw.
Directly, it had to be something indirectly around. If her parents didn't do it directly.
He's saying if her parents didn't do it directly or indirectly.
It had to be something indirectly around. I agree with her.
So when you found out that a body was found just around the corner from where you were, and the body has been dismembered with a saw.
I didn't know that the body was.
Okay, and whoever this is, he says, and then you found that around the corner from where you work, there was a dismembered body that was something about done with a saw. I know, I'm like, wah, wah, wah. I'm trying to make out what he's saying and try to help. Waffle House roofs. Oh my God, y'all are off the rails. Stop it, Cindy. Don't distract me. I'm trying to attentively listen and figure out what this man is saying.
At all.
You know, the body was dismembered?
I heard that. Nobody ever said so. I didn't hear about that.
He says, I heard that. I didn't never hear about a saw. And the officer, whoever is interviewing him, says it was in the autopsy.
Nobody ever gave him an autopsy. Nobody said that to me. I didn't know that until it was on the internet. Honest to God.
So what motive would her
and
family
you saw
have?
something on the internet. What motive would who have? What?
Honest to God.
So what motive would her family have?
What motive would her family have?
I mean, to me, it sounds strange that they got away with this stuff for all these years, and then all of a sudden, right as we split up the middle right there, and all of a sudden he ended up guilty. I don't know if she came to them with money, or
Do you think it's likely that her own family murdered her up?
man, her own family killed her family and friends.
Okay, I don't know why the state is playing this because it's not going to help the state. He said, so you think her family had something to do with it? And he says, well, man, her family killed their own family and friends. Why would this help the state?
Yeah, I know he committed murder, That.
So his family and friends.
What he.
Killed his family and
why he killed him,
friends.
What would get involved with
Hey,
that?
man, that's a big deal.
He's involved in, your family's involved in criminality, and you're trying to protect yourself from going to jail. That's a motive to kill someone. She was, what motive would he have to kill her?
Well, we knew what he did. Her dad was like
So you weren't worried about him coming after you? I mean, he's gonna cut up his own daughter and cut you up.
oh, he come after me. I didn't do anything.
And he don't want him to come after him for saying anything because he didn't do anything. So now he's talking about Carl Patton coming after him. This is not, I don't know where this is going, guys. I'm just repeating what I'm hearing.
I didn't come in. Here's what I'm saying, okay? I don't know if she needed money or it may have come to him and threatened him any kind of way.
Don't know if he or she needed money and squirrel, Cindy, squirrel. Damn it. I told you the other day we were being punked. I'm telling you.
And, you know, and they did it, whether they were drunk, it's one thing that I don't know. But anything I say at this point is speculation because I don't know.
And now he says anything I say is just for speculation because I don't know. How is this helping the state? I don't get.
But I feel like the hell if there's serial killers that have killed their family and friends, and something happens to their family.
And I feel like if her dad's a serial killer and he does this to his family and friends.
Okay, first of all,
Serial killers operate those. Okay.
Let's say what it is, okay?
Well, I'm not here to talk about, I'll deal with their family.
Right. Well, let's look at the facts. Facts. You said that she was put in bags, right?
And now the guy says, and you're saying she was put in bags, right?
Welcome to the internet that she was in a lot.
I didn't say that.
So she put in bags.
Well, I didn't want to say that.
So we're being traded.
Yeah,
What I'm trying to help out. I'm trying to
What I
get this
understand, from what I understand, the body parts had washed out of an area onto the street. Now, there were bags recovered there.
And the detective saying body parts were washed out in bags into the street the other day.
So, to make the assumption that they may have been in bags, yeah.
Okay, and now he's saying something about may have been bagged because I think this guy must have seen something on the news or read something is what he was saying earlier, something about the news.
I wasn't there to see, so I can't.
Nobody has been straight up with me on this, okay? And everything that I'm learning is basically through the internet. And we all know how the internet lies. It's a whole,
I agree with you 100%.
everything that the internet says about me, whether they're different names, try to hide, and it's hard to lie.
And that's why I'm asking you about that, because I'm not going to go off on speculation from the internet.
So he said something about whatever he found on the internet. Hold on, I'm glad that recording's over.
Throughout
That
the
was
trial, you
anxiety.
heard from the testimony of Dr. Rosa James. She was a domestic violence expert. She had hundreds of experiences with persons that have been victims and perpetrators of domestic violence. She was able to tell you about some of the cycles of abuse, talking about tension building. The beginning of 1998, we talked about the incident, the different phases where there's an incident, then there's a reconciliation, and then there's calm. And so ultimately, what we have from the beginning of 1998, when Melissa starts working with the sister, we have a representation of what that expert was talking about. We have the tensions, we have the incident, we have the reconciliation, I'll call that July 29th, and then we have the subsequent calm until we have the disappearance of Melissa. And I would submit to you that testimony of the expert, of Dr. James, is relevant testimony. It's testimony you can and should consider in evaluating what's been presented in evidence of domestic violence. And I would ask you to put the appropriate weight on her testimony and use that in the determination. Dr. Mark Gilbo is an anthropologist with a specialization in skeletal remains and analysis of skeletal remains. He was able to say he observed saw marks on the remains of Melissa Wolfenbarger. And as far as the exhibits that he was able to go over, exhibit 34, which you'll have, you see the example here where he's talking about the part of the bone that had been shaved down. And you have the next exhibit, the autopsy of the remains of Melissa Wolfenbarger.
Where did he go?
You see where the saw marks are that were indicated by Dr. Gilbo.
He's not on my
what he
screen.
observed.
Tell him to come back so I
And
can
then
see
you
him
have the
working.
ridges here, where it also appears that there's some type of mechanical saw or device that is being used to dismember the remains of Melissa Wolfenbarger. I'll submit to you, those are facts and evidence along with the fact that this defendant was in possession of the saw, the fact that this defendant borrowed the saw from his job, the fact that this job never got the saw back. Those are all facts to be considered. Those are all logical, common sense deductions to be drawn. And then the testimony of Dr. Cherry. You heard about the analysis and testing, in particular the swabbing of Norma's mouth, the analysis of the dental records, and that ties directly into the additional analysis and tests that Detective Stein did when he activated Detective Shepard. And we have that additional testing where, even though it didn't result in anything useful, Detective Stein was able to retrieve the bags and submit them for additional testing. And I submit to you that those bags were outside for who knows how long. I submit to you that there was evidence that the head had been moved. I submit to you that George McEachran encountered that bag along with his daughter. I submit to you that Tina Miller, Fulton County Medical Examiner's Office, responded to that location along with Detective Kelly and the Atlanta Police Department. And even though that did not result in useful information, the process is important because it's important to cross every T and dot every I. And in this investigation, that's a part of the process, and I submit that to you. And at this point, ladies and gentlemen, I'm going to sit down. The defense will have an opportunity to address you with their arguments. I will submit to you that this case is not about the family of Melissa Wolfenbarger. This case is about the tumultuous relationship between this defendant and our victim, Melissa. He wasn't able to control her, and when he lost control, he murdered her. That's what the evidence is shown. And at the conclusion of the case, after the judge charges you on the law, when I ask you to vote the truth, and that's guilty on that count of murder in this indictment.
Thank you. Mr. McDermott, does the defense wish to make a closing statement?
Yes,
Closing
Your Honor.
argument? Thank you.
Okay. Everybody take a deep breath. Stretch. I know I need to stretch. Oh, goodness gracious. Oh, and I love TCN pointed that out. I didn't go to court because I got high. I didn't clean my room because I got high. I'm sorry, guys. I should stop. Calm down. I'm sorry. I really went off the rails with that one. What a song. What a song. What a flashback. Afro Man. Okay, stop.
Just a short word about how this works. The state gets to split their argument. So they'll make an argument, I get to make an argument, they get the last word too. Okay, first word, last word, and I won't get three votes.
I'm going to turn him up a little bit, so hopefully it won't be too much like static in the background, but I need to, I think I might, Cindy. Stop. Okay. Where was I? But I'm gonna turn him up a little bit so we can hear him a little bit better?
That's just the way it is. We accept that.
I don't like the hum in the
You've all
background.
taken an oath. And you've taken an oath. The judge will instruct you in just a minute. Not my words, not their words. The law that will require you to decide this case based on the evidence. Based on evidence. You remember in my opening statement, I told you that the state has got gaping holes in its case. And that the state is going to give you bits and pieces of evidence. And then it is going to tell you a story to fill those in the way that suits them. And it's going to ask you to imagine along with them that that story is true. And it's going to ask you to make a leap of logic at the end of it. From alleged instances of abuse to murder. And I have asked you to follow your oath, to follow the law, and decide the case based on the evidence, not on the imagination. Let's talk about the evidence a little bit. You've been told about the difference between direct evidence and circumstantial evidence. I won't rehearse the story, the lesson. What hard evidence exists in this case? I will submit to you that not one bit of direct evidence in this case points to that man right there. Not one. I'm not saying there's no direct evidence in this case. There's lots of it. There is obviously the remains. There is the manner in which those remains were recovered. We had the head discovered in the street on April 29th. We're not exactly sure how it got there. One detective thinks there was a great rain event that washed it out. Another one says there was a dog. We don't know. And then about a month later or so, they discovered several bags in the wooded lot behind the trucking business. Some people call it a junkyard. Come back to that. The medical examiner eventually is able to identify the skull using dental records, dental charts. And notes that there are tool marks, of course, on the body parts. After some time goes by, we also know that there was a search of Christopher's former residence. There was lots of evidence taken from this. Lots of evidence that came from the remains. As we talked about before, there were paint chips in the hair. There were human hairs, apparently not Melissa's. There were pubic hairs, a pubic hair. There was DNA evidence. There were carpet fibers. There's lots of evidence. And you heard the detectives sit there and tell you, we specifically sent this off for testing. Some of it more than once. Whoever's hair that was in there that wasn't Melissa's was also not his. Whoever's pubic hair that was also not his. Wherever those paint chips came from, it was not from his residence. Someone says, oh, it was remodeled. It may have been remodeled, but folks, when you paint over paint, the old paint's still under there. And you go scrape a paint sample, you're going to get all of it. None of it matched. There was luminol evidence. It sprayed the entire house, not a drop. And finally, the more modern DNA taken from the bag. You heard Detective Stein sit there and talk about the event where they went out with all the media to the site, looked at the proximity to where Christopher had worked. You heard him testify about the DNA in the bags, and he read the results of those reports. Yes, we found DNA. Yes, there was a viable profile that represented 5 people. Two of whom at least were male. And they submitted Christopher's DNA sample. They went up specifically again to get new DNA from him and submit it for that test. That was in 2022 or so. Christopher willingly submitted. Yeah, he knew the DAs were still investigating him. He didn't run from it when they called him and said, hey, we'd like to get your DNA. And he submits it, and you heard the results of the test. Christopher Wolfenbarger is excluded from being a contributor. Well, that's when we hear this theory about there was a great rain flood event. I gave this page from the weather reports. The National Climatic Data Center for the city of Atlanta in April of 1999. I gave it to Detective Shepard. And you saw him pretend he couldn't. Or I believe it was done, I gave it to Detective. And you saw him pretend, oh, I'm not comfortable reading this. This document's going to go back with you into evidence. And you all can look at it. And if there's a single one of you who can't figure it out, I would be shocked. The days go down here, the days of the month, the hours of the day go this way, and at the end, there's a cumulative total of the rainfall for each day. And you'll be able to look at this document and see that on that day, the other deputy who said there was an intermittent mist was correct. There was roughly 1/4 of an inch of rain for the entire day. And most of it appears to have fallen at about 3 o'clock in the morning.
He's still talking about that. I'm gonna pause for a second. He's still talking about the rainfall and that piece of paper that said that the precipitation, mind you, was different than what the officer was saying, because the officer, I think he said it was a downpour or something like that, and I'm not sure if he misspoke or if he doesn't actually remember. But you know, it's like he's telling him that he's going to send this paper back that had the weather for that day on it. But what does that prove? I mean, for that day, for that week, for that month, I mean, just because it rained 2 inches in Houston doesn't mean that it rained 2 inches in Sugar Land. I mean, they're only 10 miles apart. Not even 10 miles, but you know, I mean, so I don't find that he's really going anywhere with that, but he is putting on a better presentation than the state did, in my opinion.
Before that had appeared on the road that day. And you can look up the rest of the way. 0, 0, 0, 0, 0, 0, 0, 0. Detective Shepard, oh, it rained so much that month. No, it didn't. They analyzed the carpet fibers. They could find no match in Christopher's house. So then we're told about the circumstantial evidence. It's interesting to me that you just heard the district attorney tell you all the facts and evidence in this case point to one man. But he's not talking about this hard evidence, is he? Because there's a bunch of that and not a single bit of it points to this man. All of it points away from this man. But Detective Shepard, or maybe it was Detective Calhoun, one of the two, got on the stand and said, there's only been one suspect in this case from day one. Well, when the results keep pointing away and pointing away and pointing away, maybe there should have been a difference. Maybe you should have asked some more questions of the neighbors or the family. You heard the detective, the district attorney here tell you. That's how we conduct investigations. We look at the person's life. We want to find out what's going on in their life. They never investigated that family. They never investigated anybody else. Where are the records of the test of paint chips for a single other person's house? Where are the records for a search warrant from a single other individual's house? Where are the search warrants getting hair or pubic hair or DNA from anybody else in this investigation? Crickets. Because they want to tell you a story about domestic violence.
Rita, stop.
I'm a supporter of
Thank
Me
you,
Too.
love. Stop. I'm number one. I wish I
Domestic
was.
violence is a real thing. You've heard the district attorney tell you multiple times now. This is a case about domestic violence. It may have that question in it somehow. Certainly it does. It is an issue you're going to have to decide. You're going to have to decide how much weight to attribute to those alleged incidents. And you're going to have to decide, as a fact finder and determiner in this case, how it fits into the overall picture. But this is not a case about domestic violence. This is a case in which a man is charged with an act of murder. And the state has not given you one single instance or bit of evidence about an act of murder. They want to get you sympathetically on the board. After he tells you, don't judge this by sympathy. But then he wants to tell you all these violent instances, and he wants to embellish them. He punched her. That's not an evidence anywhere. He beat her all the time for the whole year. That's not an evidence anywhere. And they want to tell you that story and then ask you to make the leap to there must have been some act of murder also. What about these instances of domestic violence? We heard from first about the July 1998 incident. Yes, there's a police report. We had a police officer testify. He told you he did not look under her clothing. How could he have known if there were scrapes on her back or backside? He told you that. I didn't look at that. We get home and Norma says, well, I got home with her and she had scrapes all down her backside. Just after she had gotten done telling me that she was wearing blue jeans. I'm not sure how you get scrapes if you fall on the ground with blue jeans on. You have reports from Tina. Tina says she came in there with choke marks on her neck. And there was another guy named Clint who stood up for her. None of that story is corroborated by anybody else anywhere. The only person who's ever told that story is Tina Patton. Tina says she took Melissa back up to Chris's house on Brookline and confronted Christopher. But Christopher tells Detective Stott in his interview that he didn't like Melissa staying with her sister because she got her into cigarettes and also was doing meth. Not necessarily that Melissa was doing it, but that he didn't like Melissa around that stuff. Well, I think there would be a confrontation when she brought her up there. We've heard from Mr. Dixon about domestic violence. It is funny to me you should find it incredible that when he gives an interview in 2003 to the police about Melissa, he does not one time mention abuse, marks on her body, being drugged on the sidewalk, her complaining about her husband. He does not mention it one single time in an hours-long interview. And suddenly, when they find him at the last minute before trial, they find out he's been watching true crime shows about this, and suddenly he remembers this incident where she had bruises and she was drugged on the sidewalk. The testimony is not credible from the former Waffle House employee and bank robber, Mr. Dixon. You heard evidence from Miss Cooley, lived across the street. She seemed to be confused about a lot of her facts and details.
Dude, I'm sorry. I need to pause. Don't talk about Miss Cooley. She's an old lady that porch sits, and sir, y'all, don't. Let's
But it was difficult to follow. But she says, "Oh yeah, I heard screaming and breaking glass over there all the time. There was apparently no glass left in the house." Definitely from that house. Definitely that house where Chris lived. And I know that because that's the house I went in and cleaned. I cleaned all the houses that Mr. Holyfield owned. Who's Mr. Holyfield? Holyfield didn't own that house. You heard testimony from several people. That house was owned by Christopher's parents. Miss Cooley was never in there. I think Miss Cooley's confused as to what she's talking about. Well, I definitely saw a black eye behind the glasses. And then she said a few moments later, I only saw her passing a few times when she was getting in the car to go to the grocery store. Never talked to her, just said hi. Testimony about Saul. Oh, he had access to a saw phone. Well, their memory seems to be just as cloudy and hazy as a lot of people. And this is a 26-year-old case, that's understandable. But I look at the statements that were made, and I see at least 4 different versions of that story that have been told. In the original detectives' reports, they said they saw went missing while Chris worked there. And we thought it was Chris. We blamed Chris. And we never found him. And then later it turned into he stole a saw. And then later they backed off and said, well, no, he asked to borrow a saw, and we never gave it back. You heard them. Their own witness, they had to impeach him by playing things that were in audio because they said they didn't even remember saying that. And they testified here that he took a saw, not saying he stole it, whatever. And she didn't even remember talking to me a couple weeks before that, before trial. She didn't remember telling me on the phone that, yeah, he brought it back.
all these inconsistencies that he's pointing out, I really think is going to benefit them. Not knowing what the verdict is. I have not looked it up. I have not looked anything up, but yeah.
Circumstantial evidence about alleged conflicts in Christopher's statement. What conflict did you hear in his statement? Inconsistencies, that was the word. There were inconsistencies in Christopher's interviews. And they played for you the interview with Mr. Stott 2001. And then they played for you the interview with Detective Shepard in 2021. In one version of those stories, in the 2001 interview, Chris tells that the last time he ever saw her, she was walking down Lee Street by the MARTA station. And he stopped to pick her up, took her up the road to Taco Bell, right by the interstate. And when they were done talking, apparently she talked about wanting to get back together. He said that was too emotional for him at this point, and he dropped her off back at the train station. And she left back north. Lee Street, MARTA station. How far is that from Christopher's house? Because when these new investigators came in 2021 and tried to trip him up with this stuff, all these details from 18 years or 20 years prior, they asked him a specific question. Do you remember telling him the last time you saw her, she was walking down Brookline Street? I'd be a little confused too, because he never said that. Now, whether he remembered the other statement from up Lee Street or not, I don't know. But again, you're 20 years later. Is Christopher the only one in this entire trial that doesn't get a pass on memory? When witness after witness is standing here and say, I can't remember that, I don't recall. At least the police officers get to carry their report with them and read the details and pretend they remember it. This business about hiding. Oh, Christopher cooperated with police time after time after time. I don't have to list it all tediously again, all the DNA results, the hair, the pubic hair, everything else. Every time they called him and said, we want this, he showed up. They could have showed up at his door that day. He would have walked out to them. They could have arrested him right there. But they chose to use some kind of SWAT team enforcement with unmarked cars, no lights. If you ever see the video again, you will notice when those cars pull up, no lights are on. Later in the video, when they're all up at his house, then they have their lights on. They don't turn it on until later. No marks on those cars. The only marked car was all black with black letters. So if you're viewing that coming up your driveway and armed men get out with M16s, what are you going to do? Walk out and greet them? Look, it was rational to fear that, okay? It's rational to be afraid. Imagine if you're seeing that through a home security video and you can have even less resolution. And so in order to connect their stories about domestic violence, to embellish them, and then create a story that somehow leads to a murder, they bring in domestic violence expert. And she tells us what she tells us. Much of what may be valid in certain contexts. And she says, well, if you're leaving, that's a sign of domestic abuse. But if you're returning, you can also explain that as domestic abuse. And if you're at any point in this cycle, virtually any behavior can be explained as part of the cycle of abuse. And Ms. Hilton gave very pointed hypotheticals, clearly designed to apply to this case. And she says, yes, clearly that's domestic abuse. Yes, clearly that's isolating somebody. Yes, clearly that's reconciliation. Yes, yes, yes. No hesitation whatsoever. But when the defense just tweaked the hypothetical just a little bit, her answer was what? Yes? No? No, her answer was, I don't know. I need more facts. I need to know what the abuse situation is. And wait a minute. How can you jump on a hypothetical when she asked it, and when we ask it, we get him hauled around? And it turns out she's a former employee of the DA's office. She's effectively like having an extra prosecutor up there on the stand to hit softballs they throw at her. So what you have happened is you have the state telling you a story that they want you to believe that leads to a murder for which they have no evidence, an act for which they have no evidence, an intent for which they have no evidence, and an unlawful killing for which they have no evidence. They want you to follow their story to judge something based on no evidence. And all the other evidence in the case that points away from Christopher, every bit of hard evidence in the case that points away from Christopher, they spend their time trying to fight against that. Normally the roles are reversed. Normally the state's putting up the hard evidence and the defense has to say, well, that's not right, this is not right, that doesn't apply. But they wanted to, oh, well, the DNA must have been corrupted because of a rainstorm or whatever. But literally all the evidence points away from Christopher, except for the story. We've been told, or you've been told, that the defense's story, the defense is Carl Patton did. We've never said that. And we've certainly never singled out Carl Patton as the only possibility. I want to share something with you that you're also going to hear in a few minutes. And this again is from the law. An interesting thing the DA said a while ago. He said, they're trying to tell you that Carl Patton did this. But the standard is proof beyond reasonable doubt. They haven't given you proof beyond reasonable doubt that Carl Patton did this. Well, that's not quite how it works. The only person in this room for which the standard of proof beyond a reasonable doubt applies is the defendant. Any other evidence, you're allowed to determine how you think it may apply. How it may fit the case. And this is the law that she's going to read to you in a minute, not the law he just told you about. This is the law she's going to read you. Of course, you have to prove everything beyond a reasonable doubt. And in a case like this one, where the only evidence against the defendant is circumstantial, our statutes and our courts have determined that this is how you should interpret beyond a reasonable doubt. You would be authorized to convict only if the evidence, whether direct or circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. In other words, in a case in which there's circumstantial evidence only, you have to exclude every other reasonable possibility. And friends, that's where you do get to use your imagination. I'm not inviting you to come up with Disneyland fairy tales. No, that's vague and arbitrary. That's what the statute outlaws. But if there's any other reasonable possibility to explain the death of Melissa Wolfenbarger, then you must acquit. From the evidence you have, the hard evidence you have,
Cindy,
you have remains, you know the area she lived in, you know she was going to Doraville, you know she was riding the train, you know she was getting off that train at midnight and walking from the Brookline, or from the Lee Street station to Brookline or wherever else she went regularly at night, midnight in the West End. We know she was hanging out with people who were drinking a lot. We know that at least, according to some people in the evidence, some of those people were doing drugs. And when drugs and alcohol are involved in anything, the pool of potential suspects is a chasm. I don't have to find one and bring it to you and say, this guy did it, and I can prove it to you beyond reasonable doubt. You just have to be able to understand it could have been anybody, and that's reasonable. And that's where people like Carl Patton do come in, and Norma Patton. The whole thing about the 5 murders and the dumping bodies in the river and the covering it up for many, many years. But we also find out that one of his victims was a drug dealer that Carl worked for. We also find out that he engaged in contract killing. We also find out that there was a member of their family, in some common law way, whose father Carl had killed. And he didn't find out until sometime later. The same man also hung out in that household, was friends with the Patton family, and later was accused of molesting Melissa. And Norma, and with Melissa's testimony, apparently tried to get him indicted. Does this man have a motive to get revenge against Carl? Yes. Does he have a motive to get revenge against Norma and even Melissa? Yes. Is it reasonable to believe he could have been involved? Absolutely. Is it reasonable to believe that one of her new boyfriends was involved when he found out she had a husband? When he found out or heard a rumor that she was pregnant? Is it reasonably possible that she did find out what her dad had been doing and came to him needing money, came to him with a, I will expose you? Is it possible that living in that area, she got involved in a drug deal gone bad? Why would they dismember her? Dismembering is not, it's not common, but it's not unheard of even in drug dealers. It's a way to dispose of a body. It doesn't have to be ritualistic. You don't have to be Jeffrey Dahmer. And in fact, that's what the state's alleging in this case, that it was merely a means of trying to hide a body. What if she owes somebody a drug debt? Here's a possibility. How do you know that she didn't die of an overdose in somebody's house and they had criminality in their house and they panicked and tried to hide the body? Where's your evidence? It just has to be a reasonable theory. That's what the law says. You can't rule it out. There's not one of these scenarios you can rule out. And if you can't rule it out, that's a reasonable doubt. Maybe she really was pregnant. Maybe she tried to have an unsafe abortion. Where's your evidence, sir? It just has to be a reasonable theory. If the state had done more investigation, maybe we could have eliminated some of these, but we can't. You can't rule these out. Is it possible that destitute, poor, no hope, she did take her own life, and then somebody found her body and tried to get rid of it? possible. The state has not ruled out any of these. It has told you a story about one possibility. It has embellished some of the details and asked you to imagine that it went all the way to a murder. Here's some random thoughts to consider. The bags were found in the wooded area. We heard testimony from Ms. Miller, the investigator who was there, the one who found the first bag, state that she found it right by a pathway. Now, why did they even start looking back there? She told you. She told you the owner of that trucking company said, why don't you go look back behind here, because there's a cut through that people use in a wooded area that drug dealers and other people use. That's what she said. She testified to that. And they go back there and start searching, and lo and behold, the dog actually misses it, but she spots this bag right by the trail. And we saw pictures of several of those bags that she described as being in a clearing or on the trail. Not pushed up under the brush, no attempt to hide these things. Those bags were even either thrown there to be found by somebody, or they were just haphazardly thrown there. But the least likely scenario is that someone was taking care to try to hide it. Get somebody kill Melissa and throw it where it would be found, right where Chris worked. They'll send a message. You can't rule it out. That's a reasonable doubt. The domestic violence incident expert spoke about that. Have you considered the evidence we've heard about how Melissa was raised, about how she was locked in a room, how she was, according to Ms. Waddell, stunted in her intellectual development, unsocial, very easily controlled, naive? Why is it that when she goes to Kathy's house and she says, I want to turn my children over to you, and then she goes to, writes a letter to Norman and says, no, I want to give all the custody and come see you and stay away from her? Why is it that she talks that way to one side and talks a different way to the other side? Maybe she had a power and control relationship with her mother. Maybe the power and control wheel applies in that relationship too. Maybe when she went up to get her from Brookline and helped her file her police report and helped her go file a court protective order, then took her home and helped her took her to Henry County to try to get custody back. Maybe that was exactly what Wendy was telling us. She's easily controlled, and maybe those weren't her own actions. Maybe she was being influenced by the person that used to lock her in a room every day and deprive her and control her. I think it's interesting that the incident happens in 1998, and all of the things in the power control wheel are suddenly in Melissa and Norman's favor, according to their understanding of how the law works. You remember, I asked her, did you understand that you just go down to the court and say, I want my kids back, and then give your kids back? Now, I know because I'm an attorney and I read the law. Actually, we talked about it here as well in testimony. That's not quite how it works. But Norma testified that was her understanding, and it was Melissa's understanding. So what happens? Melissa's with her at that time, not with Chris. Melissa went down and said, I want my kids back. So as far as they understood, they had custody back. They had the physical custody of the kids because they had them at their home at that time for those few days. And they had filed a restraining order against Chris, which would have required him to stay away from them. So according to the power control wheel, everything was in their favor, if that's what Melissa really wanted. If what Norma is telling us in her version of the story is actually true, there would have been no reason to go back to Chris whatsoever. And yet, she goes to her court date and dismisses it. Oh, that's evidence of abuse and power and control. But the power and control was with her mother. She could have easily stood up and said at that time, I'm done. I have everything I want. I don't need you. You can stay away from me. But she didn't. At that moment, she had a choice to go back to Norma Patton or to go back to Chris. And she chose Chris.
I don't
We're
like
told
his
this
argument.
sentimental story at the end.
Just saying, I don't like his argument.
Melissa, last time I talked to her, she said she only wanted one Christmas present. Picture of her and her pawpaw. You've heard no evidence in this case that she ever even hung out with her pawpaw. But you have heard evidence in this case that her pawpaw was a blackout drunk who slept on the couch. It doesn't make sense.
Sir, I beg to differ because I'll tell you right now, my grandfather was a blackout drunk and he slept in his recliner, but that didn't make me love him any less or not appreciate photos that I had of him. So I'm bothered by some of these statements. Sorry, just me being me, having to say shit.
You've heard evidence that Tina Patton insisted in 2003 interview with Mr. Calvin that she saw Melissa on her birthday in 1999. That was March 28th. She told Calhoun, she emphasized it over and over, I know I saw her. And she said her mother tried to get her to change the story.
And if this judge don't stop clearing her throat in the damn mic, I'm gonna freak out. Y'all, I'm grinding my teeth over her. Why hasn't she muted her mic every 5-10 seconds? I'm here. Come on, it's triggering me.
Because it didn't line up with her narrative of when Melissa had died. But if she saw her in March 28th of 1999, we know that Chris stopped working at Action Glass at the beginning of February, and he wasn't living there. It's interesting to me that Mr. Calhoun testified that no, Christopher's property was never searched by dogs. They weren't allowed to search. He sat there confidently and told me. Sergeant Lacoste on the stand the next day, and not even from our questioning, from their questioning, volunteered the fact that, yeah, there had been a dog search, and I was there, and yes, they did search the property, and they found nothing. Do you remember Ms. Cooley talking about, oh, he built a concrete pad in the back? Why bring that evidence in? Except to create an insinuation, oh, he had told somebody allegedly at Waffle House one time about that's how you hide a body. You put it under the foundation of the house and say, well, he made his own little foundation in the back. And ooh, her torso's underneath there. Well, the dogs didn't find it. So whatever that evidence purpose was, like all the other hard evidence, doesn't point to Chris. Mr. Shepard emphasized to us about the importance of the workplace proximity. This also came up during Mr. Stein's testimony. And it's been emphasized by the DAs over and over again. Showing you the map, showing you the dot on the map where it's at. And right here's Christopher's workplace. You've seen that probably 5 or 10 times. And you've heard testimony about it. And Detective Shepard gets up and drives that point home saying, well, it's more likely that that's where the body was hidden because he didn't have to carry it very far. It's right there. And you heard this testimony about how they went out to the scene and they took the podcasters with them, and they took the media with them, and they took DAs with them, and they had this big publicity stunt about, oh, here's where the head was, and right there is his place of work. I almost expect to hear the dum-dum-dum music in the back.
Okay, now he's just being a smart ass.
And then you learn about Carl Patton's murders. He killed people in his living room, wrapped them up in a camper out back, and then drove them 30 miles to dump them under. Proximity is not proof of who did it. And the medical examiner, Dr. Terry, brilliant Dr. Terry, the one I was afraid to object to her qualification. Brilliant, fascinating to talk to. Examined Melissa's remains and made a conclusion that supports my argument. Cause of death is undetermined. Well, she said concealment of remains. I think that's a little argumentative. That is a little argumentative. Because she doesn't know if it was bagged for the purpose of concealing or just disposed. Or just transported to be disposed. She doesn't know the intent of the person who bagged it. She can't testify to that. But there was decomposition, true, and there was incomplete discovery of the remains. And her conclusion is, I can't determine how she died. And Mr. Fawcett asked her a series of questions. Can you tell if it was strangulation? Can you tell if it was stabbing? No. Can you tell if it was shooting? No. Can you tell if it was poison? No. And I want you to interpret what that really means, what they're really saying. Can you determine if she was stabbed to death? No. What that sentence really means is we have no evidence she was stabbed. Can you determine if she was poisoned? No. What that evidence really means is we have no evidence she was poisoned. Can you determine if she was beaten to death? No. We have no evidence she was beaten to death. You have no evidence of a murderous act. You have no evidence of malice being formed, whether in an instant or at some point before. You have no evidence of murderous intent. Well, but it was very likely unnatural. I can authoritatively say that as a medical examiner. This was definitely not a natural death. Very likely not a natural death. You don't need to be a medical examiner to figure that out. Although there are all the scenarios I gave you that you can't rule out, such as overdose. At this point, all the medical examiner can tell you is about post-mortem injuries. You don't have proof beyond a reasonable doubt. You may have a suspicion that Christopher did it. That's not enough. You may have a strong suspicion that Christopher did it. That is not enough. You may gravely suspect that Christopher did it. And the judge is going to read you a law here in a minute that says a grave suspicion is not sufficient. You need proof beyond any reasonable doubt that excludes every reasonable alternative. The state's theory is asking you to do a couple things, and I'm winding down. The first thing it asks you is to ignore all the physical evidence and just listen to our story about domestic abuse. And in doing that, it's asking you to believe this. That man right there is so brilliant, he can pull off a mastermind murder. He didn't leave a shred of DNA. He didn't leave a shred of carpet fiber, hair fiber, pubic hair. He didn't leave a shred of anything that our most powerful forensic machines can pick up. Not one shred. And then was dumb enough to dump the body right by where he was. That doesn't make sense. Melissa was surrounded by criminals, violent criminals, drug users, drug dealers. A dangerous area of town. You heard Miss Brock say, I would not walk the streets there at night by myself. She was beset everywhere she went by those dangers. And yet the state is asking you to believe what they're calling an abuser must necessarily become a murderer. But at the same time, that people we know are murderous somehow turned into angels. You can't believe both those things. And I would ask you not to follow your imagination on either one of them. Don't let the state force you to follow its story, which is imagination. Demand evidence that a murder happened, that an act of murder happened. Demand proof beyond a reasonable doubt that an act happened, that there was intent formed, that the killing was indeed unlawful, and that it was with malice aforethought. And when you get done deliberating, we ask you to return a verdict not guilty.
Thank you. Mr. McDermott, Ms. Hilton, can y'all come over for just a minute?
Okay, with that, we zoom. And the state is
Quick
going
comfort
to
break for you guys and for myself, admittedly, for just about 5 or 10 minutes. And so grab some coffee or whatever it is.
I think he might. I bet he does. I bet he rides a Harley. I bet he has tattoos under that badass suit he's got on. He lets his hair down. He puts on his aviator shades. Y'all, picture this. He puts on his aviator shades, his leather vest, and he lets that hair down, and he just rides free. I see it. I can totally picture it, guys. I can totally picture it. He rides free. Okay, I'll rise for the jury. You see it. I'm telling y'all. I see it. Y'all can picture it. Okay, state rebuttal.
Good afternoon. I'm the last voice that you're going to hear for the city. And we get the opportunity to speak to you last because we have the burden. And in this case, we have waited 27 years to get justice for us. And at this point, ladies and gentlemen, we have proved that this defendant killed Melissa Wolfenbarger sometime in late 1998 or early of March 1999 for no other reason except for jealousy, anger, and the fact that he was about to lose control over this woman who he had for 7 years. And I'm going to ask you all to bear with me for a few moments as I tell you and show you how we've proved this case beyond a reasonable doubt. Now, as Mr. McDermott was speaking, I'm reminded of two things. One, what I was told in law school, that when you have the law on your side, you argue the law. When you have the facts on your side, you argue the facts. When you have both, you argue both. And when you have nothing, you just argue, and argue. And that's what Mr. McDermott did for about 45 minutes. Now, I like Mr. McDermott, but he was given a tough case. And because of the case that he was given, he just had to argue to you for the last 45 minutes. And I'm going to show you how everything that he said makes no reasonable sense. Because what we ask you as jurors is that you have to make reasonable inferences based on your common sense and reason. We ask you not to leave your common sense at the door, but you bring it into the courtroom with you. And there's only one reasonable conclusion in this case. And all roads, all logical roads, all roads lead to one defendant, and that is him over there. I'm then reminded of a second story. Story that I've been told a long time ago regarding a red eye. And the story goes that there was a man coming across the border, and he had a red bike. And every day he would come cross the border with a red bike, but it had a basket with sand. And every day as he came across the border patrol guy would say, look at the basket and say, what's in here? There's something in here. Every day the guy would come and say, nope, there's nothing in there. Ride his bike every day, happened for a substantially long time. Then one day, the border patrol guy and the man on the bike was at a bar. The border patrol guy he had already retired, and he speaks to the man and says, you know, all those days and all those years you were riding this bike across the border. And every day I looked, and there was nothing in the basket. What were you doing? God said nothing. Congratulations on your retirement. The night keeps on going, and they're drinking a little. And the border patrol goes and says, you know what, I'm a little drunk, I'm not going to remember what you tell me. So tell me what you were doing. He said, no, don't worry about it. Here's another drink. It's not the end of the night. Border patrol was like, look, I'm getting ready to go home. I've been drinking a lot. I'm not going to remember what you told me. Tell me what you've been doing. He said, you know what, I'm telling you. He said, you know, every day when I was coming through with the red bike, you were so focused on what was in the basket. But I was smuggling in a new red bike every single day. But because you were...
Wait. What did that say?
Focused on every...
It says, sorry, y'all. I'm blind. I have to put on my glasses because I can't read in this red thing they got going on. I can't see it, but I want to see what I need to see what this says. It says, what is right is often forgotten for what is convenient. Bodie Bone. What is right is often forgotten for what is convenient. Okay.
Single theft. But because you were focused on what was in the basket, you were missing what was right in front of you. And what the defense counsel has asked you all to do is focus on all these reasonable theories. And we're going to talk about these reasonable theories in a moment. And not focus on the path that's right in front of you. And like I said to you before, the path that's right in front of you leads straight to Mr. Wolfenbarger. Straight.
Okay, she might hit this home, guys. Wait.
So let's talk about some sand in the.
Let me stop a minute. Let me retract myself. Let me see how because she's handling this a little bit better than it was handled earlier. Oh no. I'm gonna listen. I'm gonna give her a chance.
Box, the basket, let's talk about it. First, no physical evidence. That's the first thing, right? We talked about the paint chips. Let's talk about when they went to the house. They went to the house in 2003. What happened in 2003? What do we know? Well, what we know from Dorothy is that he abruptly left in February, sometime in 1999. He didn't tell his friends he was leaving. He didn't tell his Dorothy, the person he would hang around with every day. He left all the clothes in the house. And what did Dorothy tell you? She had to come and clean it out. And then what did you hear? That it was remodeled. It was changed. So
okay, and they didn't read that slide. That slide says sand in the box. No physical evidence. Paint chips 4 years after remains house been remodeled. Defendant move. We don't know what the house looked like. Next line says bags. Multiple people with access to the bags. Next line, no blood after luminol. If she was strangled, there would be no blood. Okay, that's true. Pubic hair. Oh, y'all, I'm sorry. I said that word. Y'all, I hate that word. There's just something about that word. Okay, hair. She was having sex with another person, Thomas Dixon. So when she died, his pubic hair. What? Nobody. They didn't. I don't. What? He knows how to hide a body. So he knows how to use gloves, bleach, saw, and discarding of body parts to conceal his acts. Okay.
and then what did you hear? That it was remodeled. It was changed. So of course, in 2003, when they go and do it, the paint chips don't match. Now when it tells you, oh, well, the paint chips stay the same, you don't know what all the remodeling was in the house because it had changed. So there wouldn't be any paint chips that matched what was in her hair. Next, we talked about the bags that his DNA not found on. But Mr. Fawcett talked to you about that. If we believe when the last time anyone besides him seen her, we know that in February of 1999, she didn't call her mother for her birthday. We know in March of 1999, she didn't appear for the court hearing for the battery case from July. So we know she's probably deceased, I would suspect, somewhere after Christmas of 98. Probably January or so of 99. So those bags were probably in that area for at least 3 months before they found them. People could be touching the bag, not realizing that it's a head in the bag, not realizing what's in it. They're picking it up, they're putting it away, whatever they're doing, there's other DNA on it. He already told you, because that's what he told Tina, what did she tell Tina, Miss Karen, all of them while they were sitting at the Waffle House, he know how to hide a body. Well, I suspect he know how to use some gloves to hide the body.
And I need to make a comment about the weather again and the time frame, because if she had been out there, let's just say since January, just guessing, and all that time, and they found the bags later and they were wet. I don't know about that area, but I'm assuming January, February is rainy season. At least I mean, it is here, so it's wintertime. So condensation in the bags and all that they kept talking about. I don't know.
He knows how to use some bleach. Remember someone said it looked like there was some liquid in the bags? See, you have to remember all of the evidence that came out. Well, he had the reciprocated salt. So let him chop up the body. Where's the torso at? But we're going to get to the torso in a moment. And he discarded it. So that's why his DNA wasn't on the bag. Let's talk about the blood, no blood after they moving on. Well, if she was strangled, there would be no blood. And is it reasonable he strangled her? Yes. You want to know why? Because her sister told you that she came in to the Waffle House in early of 1998 with strangulation marks on her neck. That's what she told you. So is it reasonable that he strangled her? Yes. So that's why there wouldn't be any blood. So that's why if they luminol, there wouldn't be there. Well, we know he strangled her. What do we know from Dorothy? He punched her. What do we know from the report? He dragged her. That's the way that he harmed her. There's no evidence that he used guns or knives. All of the evidence shows that he used his physical hands to hurt her. So is it reasonable that he strangled her? But it would be nice if we had her neck to really be able to tell you what he did. But see, they don't want to talk about that part of it. Let's talk about the pubic hairs. Well, what do we know? Thomas Dixon told you that they were intimate. What did he also tell you? The last time he saw her was in December of 1998. Could it be that the day that, remember when he said the last time I saw her, she left with him? So now you're pregnant, probably by the time this. You're left with him, so now I'm mad because you want to leave me. And I strangle you and kill you. You're right, pubic hair could be Thomas Dixon. So the fact that there's no physical evidence doesn't mean it doesn't point to him, because there's a reasonable reason why there's no physical evidence. No physical evidence. So they showed you the rain shower report. Well, the only month I see here is April. If she was died in January, February, or March, where's the rain reports for those months? You have to start thinking about what they want to give you, because they want you to go all over the place and not on the right path.
Thank you, Lois.
Her body was sitting out there for months. She was severely decomposed. What did the MD say? I can't even tell you.
Look, wait, what did that slide say? Wait, go back. It says, sand in the no physical evidence. April rain showers. They didn't bring you January, February, or March report for showers. See, y'all, this is what I was saying. I promise you, I have not watched. I was having trouble with what they kept talking about the weather.
What did the MD say? I can't even tell you. It could be 30 days. It could be longer than that. I submit to you it was longer than that because her mother did not hear from her in February. Let's look at the evidence, y'all. And that is evidence. That's what came out on the stand. Because everything that came out on the stand is evidence. Sand in the box. Don't believe any of the state's witnesses about you. So everybody lying. Tina doesn't know Dorothy. Remember, because I asked her. Dorothy don't know Tina. But somehow they both saw Melissa with bruises. So they both lying? Why? What would they need to lie for? Matter of fact, Miss Dorothy, if you remember, if you watched her, when she came in here, she looked over at him. I guess she remembered seeing him from back in the day. and she kind of got a soft look on her face. And she tried to switch it up on me. If you can remember, because first I asked her, did you hear yelling? She's like, I heard both of them yelling. And I said, is that what you told me my investigator last week? And she said, well, that's not what I said. And she changed the story. She wanted to help him. See, y'all gotta remember those little things. But then, as she was getting crossed, if you remember, she said at one point, I used to hear her scream. She said, I used to hear her scream. What did she tell you? That she heard it 3 to 4 times a week. Let's assume that they moved over to Brookline in January, February 1998. You know, we lawyers, I don't do a lot of math. But she 3 to 4 times a week. So take 4. So I'm good with that. 4 4 is 16. Times that by however many other months. How many times was she hearing this poor baby scream every week? But they want you to believe that no domestic violence was happening? You gotta start thinking about the evidence, y'all. Because they talk to you about that.
Y'all, we're going to pause and we're going to read this shit because I'm nosy. It says, saying in the box, don't believe any of the state witnesses about the DV, the SAW, Tina, and that's not how she spelled her name. She spelled it Tina and pronounced it Tina. Dorothy, Miss Holyfield, Kathy Wolfenbarger, or Mr. Holyfield, Dorothy, that was Miss Jones. Just depend on the day. Thomas Dixon, the Brocks, Mr. McDermott didn't play the interview in which he claims that Cindy Brock said the defendant brought the saw back. The only evidence you have is what the Brock said. He borrowed the saw and never returned it.
Thomas Dixon, he don't know Dorothy. He don't know Tina. But somehow Melissa was able to tell him about what happened to her in July, but he comes to him, he's lying too. Remember when he told you that I had been in prison for about 10 years and I saw her missing face on some cards. That's how he remembered that that's how he knew she had passed. And wanted to tell everyone about what she told him. And is that unreasonable?
Yes.
Because maybe he was her peace and solace to get away from him. You know, he asked questions about them being on the roof of the Waffle House. Maybe that was the only place she could get some peace, on the roof of the Waffle House.
Okay, we're all going to the roof of the Waffle House.
From
Y'all
him.
want to join me?
What did? Now I know she said all she was smoke take heroin every day. But what she tell you today? That when she called her friend the last in 1998, he didn't want her to speak to anybody. So we're supposed to disregard all of that. I submit you don't do that because that's evidence. Now the Brocks. You know, he said, I guess he claims that Ms. Brock told him on the phone that he returned the saw. He didn't play that interview for you. He played Wendy's interview. So where's that interview? The interview you heard is when the Brock said he borrowed the saw. Matter of fact, they corrected the police. The police said, he stole the saw. No, he didn't steal the saw. He borrowed the saw. And they said on their own, and he never brought it back. And they told you, that's not the reason why we fired him, but he never brought the saw back. And remember what we asked them earlier? In the culture of that job, they don't really ask what you use the saw for. They just use, they let their employees borrow the saw. That's evidence. Because how ironic is it that her body and the bones have lines from a reciprocating saw that he so happened to borrow from the job that he worked at. And it hasn't been returned. Ladies and gentlemen, this is evidence. And then, this whole thing that he was cooperative, he gave DNA samples, he did this. Well, he did those things because he believed he covered up the murder. He believed that he did what he needed to do to cover up the murder. But when it is time to now be held accountable, what is he doing? And we're going to see the video of that in a moment. He first sends his girlfriend out to say he's not home. They skip over that part. When the police get there, she opens up the door, she comes out and says he's not there. But what did O'Hare say? Because of the cell phone, they knew he was in the house. So he kept looking. And y'all saw the video, he looked, I think he thought he was behind that mirror, and kept on going back to that mirror. And then eventually he's like, oh, he's here. And he knocks on that makeshift thing that he done cooked himself in.
Sorry.
But he's cooperative? This is gonna, when I go through all their reasonable theories, the medical exam. What did she tell you? In her expert opinion, she did not die of natural causes. It was undetermined by highly likely homicidal violence. And what did she tell you? If we only had the test.
Okay, it says, saying in the box, medical examiner analysis. She said, in her expert opinion, did not die of natural causes. It was undetermined, highly likely of homicidal violence. If we only had the torso.
And why would we not have the torso? Could it be because she was pregnant?
Yes.
And he wanted to make sure that we never found that part of her. So you're going to get this instruction from the court, and this is what Mr. Fawcett and Ms. McDonald discussed. You will be authorized to convict only if the evidence was direct, circumstantial, or both, excludes all reasonable theories. Reasonable. Your duty, when you go back, a reasonable doubt is a doubt of a fair-minded and partial juror honestly seeking the truth. It's not arbitrary, it's not vague. So let's talk about their reasonable theories. So the first one, a random person in the West End decided to kill her child and decapitate her and cut off her legs. What evidence is there?
We're going to read these off real quick before she goes through them. All reasonable theories. A random person in the West End hanging out with people who does drugs and alcohol. Child molester revenge. Okay. New boyfriend. Drug deal gone bad or overdose. Carl and Norma Patton or those are a little far reaching, but okay.
There's no evidence. The only evidence of her walking down the street comes from the defendant, who has all reason to lie. We're going to talk about when he says this idea of her walking down the street. That she's hanging out with people who do drugs and alcohol. Who? Who? That's not reasonable. There's no evidence of it. Next is the male, they don't have his name, who molested her as a child. What evidence is it that he came from wherever he may live to come all the way to Atlanta to kill her? To use saw to cut her, to put her in a bag, to discard her across the street from his job. What evidence? There's no evidence. It has to have some evidence behind it. Not just, oh, you think this in the world. Not that it's a possibility. It has to be reasonable. The new boyfriend, Thomas, he told you the last time he saw her was at the Waffle House. You can assess his credibility. There's no indication that he even knew where Avon Avenue is. They sure didn't ask him. They sure didn't cross him on that. Because if you really suspected it was the boyfriend, you would have crossed him on it. The same way they crossed it, Norma, or what her and Carl did, they would have crossed Thomas on that. They didn't. Because they know that's not reasonable. There's no evidence of it. You can't just pull it out of the air. That's not what justice requires. That's not what we ask of you. A drug deal gone bad? Since when is she a drug dealer? Where's that coming from? An overdose? What you heard is that most people, everyone's trying to keep her away from drugs. Remember Wendy said when she was doing meth, she didn't want her to do the meth. What did Tina say? I was doing my thing. I didn't have my sister around me when I was doing my thing. So where's this evidence? They're throwing things to the wall, see something will stick. Suicide. Well, and we told you that that's not the case. What, you gonna kill yourself? Well, why would someone, like, that doesn't make sense. So someone finds you dead and now they feel like they need to discard your body in a way. Why would they just leave you there? If it was a suicide. And then Carl and Norma Patton. You know, when Mr. McDermott said, we're not saying it's Carl and Norma Patton, my mouth dropped. Every cross-examination was about what Norma and Carl did. That they had something happened in their living room. That Norma helped them in the living room. But what they didn't talk about is that Carl and Norma were looking for their baby when they didn't hear from her in February 1999. That they drove from their home in Stockbridge to go look for their child. That even when Mr. Patton got arrested in 2003, the first thing he wanted to do said, you got me? Go find the person who killed my child. That's what he said. Norma said, look, you got me? I'll testify against my husband. Find the person who killed my child. And they want you to believe that those are the two people who killed their daughter for what reason? Oh, now she wanted money. Most kids want money from their parents. I think I still ask my dad for money every day. That means he's going to kill me? Because I asked for money? Most people want to take care of their children, protect their children. You have to make it make sense in it. So we talked about this, but you get to decide who you believe. You know, when you have Miss Patton, Tina, look at their testimony in comparison to Kimberly, his sister, compared to Kathy, his mother. You can assess it. Why is it that Kimberly and Kathy can't remember a thing? Nothing. I don't know. You don't remember anything? Kimberly, that's your best friend. She was with you when you was driving on the road. And you don't remember anything about what she told you about your brother? But yet, Calhoun can come in here and tell you, you said that she wanted to leave your brother. She loved your brother, she wanted to leave. She can't remember that. Why? Is it because remembering that will show that she wanted to leave your brother? And she don't want to be with your brother anymore? Mom can't remember that she never used to talk about Melissa to her grandkids? She can't remember if she went to go look for her or not? Why? But they don't want you to believe Norma and Tina. And Norma came in here and told you, this is what I did, this is what happened. She remembered everything that happened. She corrected us at times. But they want you to be so concerned about her past that you're not listening to what she's telling you right here today. I submit you, don't fall there. Don't fall there, pressure. Your duty is to seek the truth follow the law and deliberate. If for some reason you want it back and one of your members say, I don't want to deliberate, they will hide in the bathroom, come out and shut the judge. Well, you don't come out, but you should write it and let the court know.
Hide in the bathroom, ma'am.
So let's talk about how we prove that he did. We don't have to prove motive. However, any evidence of motive is admitted for your use in determining the defendant's state of mind at the time of offense. This isn't a domestic violence case. This is a case of domestic violence. This defendant used his power and control from the time that she was 15. From the time that she was running out the house, from the time she was running away with him, he began to control her. What did Wendy say? She's easily controlled. She's a follower. That she's acceptable. She's gullible. And he knew this. She's stealing cars for him or with him. She's out here leaving the house, trying to be with him. And the mom said, I didn't like the boy from the time I saw him at 15. Sometimes it's just a mother's intuition. Tension building. Tension building. What did Dorothy tell you? The argument. That's tension building. The breaking of the glass. That's tension building. The incident. The marks on the neck. The incident. The July incident. The incident. The black eye that Dorothy saw. Those are all incidents. And those are what people saw. We know sometimes domestic violence happens in the house of things that people will never see. The reconciliation. Her wanting to go back to him. The TPO hearing where she drops the TPO.
Your Honor, we would approach.
Sure.
Approach. Sir, she's in the middle of her closing rebuttal. Does somebody need to potty? Because I heard him say something about a restroom break in my ear a few minutes ago. I wasn't trying to point it out, though, but his little whispers in the background, I can hear everything he's saying. He kept saying something about a bathroom break or something.
The TPO hearing, the reconciliation of it. That is evidence of a domestic violence relationship. And if there was a calm period, she went back. We know that he went to court with her, so those could have been times of that calming period. We talked about the different ways in which we exert power and control. So let's talk about some of the ways of exerting power and control. Isolation. What did we learn? When she got to Brookline, she didn't have any friends. What did Kimberly tell you? I started living my life. So we weren't friends anymore. What did Wendy tell you? They weren't friends anymore. What did her sister tell you that, we started hanging out again more and more once she started working at the Waffle House. So her connections weren't there. Her connections were down in Stockbridge. She was naive.
Okay, y'all. I need a laughter break, a stretch break. Norma's standing on her shoulder. Norma. Why did I say Norma? Lola. Lola is standing on her shoulder. Stretch, pause. Oh, okay.
Easily influenced, believe what anyone tells her. We talked about the physical violence. Using her children. I submit what happened in that room when the judge allowed them to talk is that he convinced her his mom and kids. And she did. You give permanent custody permanent guardianship to my mother. And that is a form of control. Now your mother, the abuser's mother, now has her children. can dictate what the children do. We know that they didn't tell them about their mother. What did Ms. James tell us about the role of a perpetrator? He's the hero, the judge, and the victim. He's a hero when he's saving her from the house. A hero when he's taking her from the home, when she's running over to his support. He judged her when she wants to go back and be with her family, spend time with her family. Not allow her to talk to her family. And then when she finally decided she's tired and enough is enough, as she told Kimberly that I was done, he plays the victim. You can't leave me. Look what I've done for you. Look at how we are in my grandmother's home together. Look at how I saved you from your family, saved you from your trauma, saved you. You can't leave me. Abusive, we already talked about it. He was controlling. Melissa's fragile minded, a follower, easy
Judge
to
could have
control.
muted her mic before she did
Not
that liver
the type of
blowing.
fighter, naive,
Just saying.
dependent. Again, evidence of his controlling behavior. Motive, pregnant by another man. Because remember Thomas said it, thought it was his. And leaving him for another man. And what did Rosa tell us? The most violent time for a victim of domestic violence is when she wants to leave. Is when she wants to leave. And she was leaving him. She found solace in Mr. Dixon. And he was going to lose control of her. That is why he killed her. She was going to leave him. She was leaving him. Now let's go through a timeline very quickly. Late 1997, early 1998. She goes to Waffle House crying with a bruise on her neck. Melissa indicates to her sister that Chris caused the mark on her neck. She initially tries to confront Christopher. Melissa doesn't want her to confront him. Troy instead hates Chris. Tina drops Melissa home and confronts Chris about hitting his sister. Those are two separate times. And then you know about the time at the Waffle House where he makes an ugly comment. He knows how to hide a dead body. January to March of 1998, Melissa and Christopher moved to the grandparents' house on Brookline, again away from her family and friends. She's working at the Waffle House in New Orleans. Remember? So Melissa, March of 1998, Melissa visits her sister at Waffle House on Virginia Avenue and surprises her for her birthday. Remember when Tina testified, she said, I thought it was 99, but my mom did correct me and I realized it was 1998 and she remembered the wrestling people coming in and that's how she was able to remember the date. So it was 1998. And we know it's not 1999 because if you believe what her mother tells us, she did not call for the birthday and and she did not appear for the court hearing in March. It's reasonable to believe she was deceased by then. Again, Melissa's still working at Waffle House in Doraville, and Christopher's not working at Action last year. He didn't start until October. January through July, we talked about this. Dorsey hears arguing, sees Melissa with glass on her face and booze under her eye. She saw Melissa with a baby maybe once or twice. You know about the July 21st APD police report. Melissa applies for a protective order. She seeks a petition to terminate guardianship on the 23rd. Temporary protective order hearing. Chris is allowed to speak with Melissa privately. That's when, after that meeting, is when Melissa asked the TPO to be dropped. On the same day, she asked her mother to pick up the children from daycare and take them to Kathy Wolfenbarger and give permanent guardianship to Kathy Wolfenbarger. October 1998, Chris begins working at Action Glass. Melissa's probation court hearing, she tells the judge that she's pregnant. November 9, 1998, Norma sees Melissa at a court hearing. She leaves the court hearing with Chris. This is the last time that Norma sees her daughter. Thanksgiving 1998, Wendy Waddell calls Melissa. Chris does not allow her to use the phone. He's controlling Melissa's ability to speak to her friends. Melissa does not call her family on Thanksgiving. December 98, we know that Thomas sees Melissa at the Waffle House. He says to Chris, because he comes in, Melissa's crying, "You can have her after 9 o'clock p.m. Chris waits outside. Melissa leaves with Chris. He never sees her again. According to the Wolfenbarger family, they see her at a family function in December 1998. Again, her family does not hear from her.
Okay, wait, y'all. Says Thomas Mike Dixon sees Melissa for the last time at the Waffle House. Melissa came in the story. Oh, please. Oh, come on, state. Did y'all not proofread these? Y'all, they didn't proofread these. Thomas Mike Dixon sees Melissa for the last time at the Waffle House. Melissa came in the story crying, and Mike says to him, she is mine until 9 p.m. and then you can have her after. Chris waits outside until closing and Melissa leaves with Chris. He never sees her again. December 1998, Wolfenbarger family sees her at family function. Her family does not hear from her. They could have done better with these slides. I'm sorry. Just my opinion.
December 1998, again, her family does not hear from her. February 1999, she doesn't call her mother for her birthday. Carl Patton goes to Tina's job to inquire about Melissa's whereabouts. Christopher is fired from the job, but he had borrowed a single-hand saw and had not returned. March 1999, Melissa is not present and cannot be located if an abandoned trial. April 1999, her head recovered is unidentified. Other extremities recovered, unidentified. February 99 of January 2000, we know that Ms. Norma Patton is seeking assistance to locate Melissa, reaches out to several law enforcement agencies that receive no assistance. She speaks to a lawyer who puts her in touch with the Henry County Police Department. January, files the Mesa Police report, Detective Scott assigned to the case. January 2000, Detective Scott does initial interviews with various family members to include or attempt to include Melissa's husband, the defendant. This is in January 2000. About 9 months later, he speaks to Karen Wolfenbarger, and she is reluctant to speak to police or give police any contact information for Chris. 2001, he finally speaks to Chris, so it's 2.5 years after the remains are found, 18 months after the missing persons report, and 18 months before the remains are identified. And here's what he says. First, about her personality. These are his words.
Yeah, we're talking about, you got to understand, I don't know what all they told you about the mentality of her. She's not real, she didn't have a lot of street smart at all. She was real smart, though. She had a lot of real smart. She was real intelligent that way. But as far as, she was real naive. I don't know that way, though, but not quite like that. She was basically, if you could put an idea in her and get her thinking about it, she would swear that's right. And I guess that's why she had so much problems running away all the time. But she was a real follower.
He said, you put an idea in her head, she will follow. She's a follower. That's how he was able to control her. What did he say about her when she stayed with him? These are his words.
So she paid to use the Bible, and then she stayed with him for a few days and stuff like that. Sporadically, yeah. I'll say almost a month. I would say 3 weeks. Because it was right around Christmas, I remember.
So what does he say? He was sporadically with her until about December of 1998. No other person besides Chris sees her after December of 1990. What's he said? Because this idea that it's Norma who did this in 2001, he says this about her mother.
There's no way I believe that she didn't call her mom. That's the whole reason I ain't even, He said, there's no reason why she wouldn't call her mom. I haven't been over there yet. In 2001, he figured she would be calling her mom. That's what he tells the police. So why all of a sudden now is her mom couldn't have killed her? And it corroborates what Norma said. She was concerned at Christmas when she didn't see Melissa, and she's even more concerned when she didn't hear from her on her birthday. So this is what you have to listen to. And he saw her in April of 1999. After she left, I didn't hear too much from her for a couple months. I was like, whatever. But back in April, the following year, which I guess would be 99, I think, and when I was coming in this street, I don't know if you know about the room like that, but I was right there, right where the train station was, and I was coming up through there, and she was walking the road, and leading just seen a white girl. I was, blowing the horn to the, we're down in red around there, But, I thought, and I blew the horn at her, and I got down the road on my Krispy Kreme trying to come back. I'm like, I got thinking who it was. I couldn't believe it, man. She was, I don't know, I guess, her sister can tell you how she looked. You got the picture of how she looked when she was white. That was like she looked like right after we got married. After that, man, she cut all her hair short, dyed it red, started smoking. She looked totally different than that.
He's talking about her appearance changes.
When I see her come back, man, she was beautiful. She off the gate down there, like, man, I couldn't believe it. You looked right on. We stopped, and she said she wanted to talk. So I went to Taco Bell. We whatever, And at the time, she was like, I'm going to stay. I'm going to come back home. I was like, the emotional stuff, whatever it's going through for me, just like this.
This is from 2001.
So what? So that was his novel.
Okay. Yeah.
But
Charlie Brown.
What he says is he saw her in April of 99 when he was driving down Lee Street in the West. And that she had bright red hair and that she had track marks on her arm. Ladies and gentlemen, in April of 1999, her head was severely decomposed on April 29th. How is it that he saw her walking down the street and able to describe that she had short red hair? What did his mother and his sister say? The last time we saw her in December, her hair was down to here. But he sees her in April walking down the street. But she didn't call her mom. She hadn't called any of her family members, but yet he saw her and describes vividly. This is in 2001. This is before her body's identified. This is before anyone knows that the remains are hers. This is when he thought that no one would be able to find her. This is what he's telling the police in the missing persons report. And you have to remember that he abruptly leaves the neighborhood in early 1999. Why? That is your mother's home, your grandmother's home. Why would you need to leave that house abruptly? There's no reason except you have to get out that neighborhood. Let's see if this one works. When he tells them later on in that same interview again that he saw her in April of 1999.
I mean, she had taken she had dyed her hair several months before, but then right there towards the end, and especially one thing in April, her hair was real short, real bright. They look odd. It looked. It definitely stood out. I mean, she didn't like nothing like that.
So he said she had dyed her hair a few months before. No one else has seen this except for him. He also says, and I'll try to play, but if it doesn't work, we'll keep moving, that she must have changed her name. Why would Melissa need to change her name? There'd be no reason for her to change her name. Why? Again, this is in 2001. He wants people to think that she's moved away and just changed her name. She already wanted to leave him. She didn't want to be with him. She already started a relationship with someone else. So what reason would she need to change her name?
I know that she would have, like say, was there. That's the only thing I think of right now. I really don't know, but that's just my opinion. And she went through, because to this day, she's still married to me. I'm not, just now, I guess going through the divorce, whatever, I'm trying to do all that. But
It's not, and I'll say this as a reminder, if there's any video that you would want to hear, you can do that if you're once you're doing for it. He also tells them in this same interview, you have to cut everyone off. Again, why would she need to do that? She had her family who loved her family who cared about her, her mother, her father who picked her up after the July 21st incident. There would be no need for her to cut anyone off. But again, he was trying to cover it up because again, this is before anyone knows who she is.
I mean, she had taken she had dyed her hair several months.
In 2002, he filed for and is granted a divorce from Melissa. He also says in that 2001 interview that he's been working on the divorce since 2001. If you thought she just went away, you didn't think she was going to come back at all? Why are you filing for the divorce? You're filing because you know she's never coming back. March 18, 2003, Detective Scott and Calhoun meet with Chris. This is a few days after the remains are.
I have a problem with that. Let me speak up. I just need to pause to get rid of the Charlie Brown for a moment. I have a problem with that. What? What? A divorce? Because she wasn't. I don't. I honestly, if I might be misspeaking here. That's my opinion. If my spouse was missing, and I'd never expect him to come back, now that I'm saying it out loud, I don't know. Filing for divorce because she's missing. Interesting thought. I had to speak it out loud, I guess, for me to absorb it. I don't know.
Identified. If you remember, they kind of confirmed his story before telling him that she's been identified. And again, in this interview, he says the same thing. He saw her in March and April of 1999. Now he says he dropped her off at the train station and that was it. She just disappeared in the night. With no one else to see her, that story is a lie. And again, he's the last person to say he saw her.
Say the year she disappeared. I've been sitting here, I don't know if it's 98, 99. I know 2000, I was living in Savannah, so it can't be 2000. But whatever year that they're saying that they seen her, I know I seen her like in early March or April of the next year. And that was the last time I'd seen her. That's November of 98 is what they're saying. That's Thanksgiving. All right. And then so end of the next year, 99, early 99, March, April, somewhere near what you think you ran into her. And he's probably more familiar with the area than I am, but so that was Hornet. She was walking from like the Martin train station up from Brookline. Is that right? Yeah. Right there on Lee Street. Y'all went to a Taco Bell in the area there and talked for a little bit. And what happened? She walked off, rode away, and
I dropped her off at the train station. Yeah, so you would drive. What kind of vehicle you have? I had a, I want to say it's a tan color Chevy Caprice, like a brown color. I mean, I can't be certain on that because I've got off of many cars.
Then he says, you know, he looked back and the last time he saw us in 2001, she looked like she was doing something. He kept on saying track marks, but now in 2003, she was better than the last time she saw her. They don't run out of time to go to speed through this pretty quickly.
What's the last?
This idea that she may have got a drug overdose, what he says is she was not on drugs while they were together. So this idea, he said.
So people do something like that, kind of just disappear from the family and just run, you know, haphazard lifestyle like that. They're already on drugs. That's what I'm too. Oh yeah, she wasn't on nothing with them together. You know, I'll say we smoke reefer every now and then. You know, just fun where we go to concerts or something, or do go out or something. You know, might drink regular alcohol or something.
She wasn't on drugs. So all of a sudden, the defense is, oh, well, she may have had a drug overdose. He says it. And it's in 2003.
She looks good. Green power suit.
He talks about the divorce being final. We don't need to play that clip. She wasn't afraid of her dad or anyone getting revenge.
Was she ever afraid either of him or somebody that, you know, might be trying to get revenge? No, against him? I don't know if she did. She never let on nothing like that. She never acted that way. No, she was always more quiet or didn't.
So now all of a sudden somebody wants to get revenge on her? That's not what he said. She loved her.
I don't get that. How much you knew was she was ever afraid of him, you know. She was afraid of her mom, but she couldn't stand her mom. I'm not really sure that's what, you know, that's what's got me stumped now or whatever, because, I mean, it always seemed to me like, you know, she loved her dad, you know, with her dad, but her mom was always, every time she run away, whatever, you know, she would come and tell me she was running away from her mom. I mean, I don't know, that's why I couldn't really say, I don't know, I just couldn't see him doing anything to her. I can see, you know, there could be a homicide or whatever.
He can't see her. This is her dad doing anything. Now in May, you've heard this interview, so I won't play it. There's clips in here, but I'll highlight
Yes,
it.
please don't play any more of it.
This is the May 5th, 2021. This is now 18 years after the head and extremists have been identified, 6 years after media attention has been brought to the case. He talks about the last time he saw her. Now he doesn't really remember. And we understand that memory fades. But the defendant nor his family can remember a thing about this woman who's the mother of his child. And you heard the interview already.
Indeed.
He thought she just left and moved on. Well, when she didn't come back, you didn't call the authorities. You didn't report her to anyone. This is the mother of your children. This is your wife. And you don't say anything? He never wanted to reach out to assist her own family, became worried. He didn't even want to speak to the police. Back in 2001, it took him 18 months to do this. Why?
When she would leave and go.
Now, all of a sudden, her parents killed her. In 2003, there's no way her dad could do it. But now that the media's been on it, now that it's been highlighted, now that the road is leading to him, he says her parents did it. And that's convenient. Let's blame the individual who was accused of a accused of killing multiple people, and let's blame him.
What do you think happened to Melissa?
2023, the police move with Captain Wolfenbarger, and the investigation continues. And then here he is, hiding behind the wine rack in here. And he's hiding just like he told his daughter. When I have to go on the run, because that's what he told him, when I have to do it, I know where to go. You saw Christina here. She had no reason to make that up. And that's exactly what he did. Had a makeshift place to go hide. Now they said that we want you to do a legal logic. No, we don't. We want you to follow the path. Physical abuse at 98. Mom speaks to her the last time in November of 98. She wants to leave him. He borrowed a reciprocating assault, never returns it. She does not call her mother for the holidays. He does not appear for the March Barry. She doesn't appear for the March Barry trial. Carl Patton was looking for his daughter. He abruptly leaves the neighborhood without telling anyone, leaving all of his clothes. Her head is found on April 29th, across from his job, severely decomposed. Extremities found in June, across from his job. He's the only person familiar with that neighborhood. His mom doesn't know where to go. What did Miss Patton say? The only time we went up there is when we was going to pick her up. They're not familiar with Atlanta. He is. Cut marks on her bones appear to be done by reciprocating assault, consistent with the type that he took on the job. Her torso doesn't recover. Could it be because she was pregnant? He never reports his wife missing. Reported missing by her mom in January. Mom's reluctant to give information. He lies to police in September. Never speaks to his children about their mother. Body parts found in ATLs. No other family resides here. This is where everything is found. From the house to the job to the location of the house. This is not a legal logic. We're not asking you to jump. We're asking you to follow the path. And all the evidence leads to one conclusion. He's guilty. Now, ladies and gentlemen, we might not have all the puzzles. We wish we had her torso. He was clever enough not to leave DNA. But what we do have is this. You can still see this dollar bill, even with all of the missing pieces.
Okay, can I talk a little smack about our dollar bill? They could have pulled a photo up that doesn't have photos.com watermarked in the background. Come on, state. They could have done better. I'm disappointed. I really am disappointed in the state. I'm just telling y'all, I am disappointed in the state.
You still see that the path leads to only one person. Only one conclusion.
Not even, and here I am, not even me as a streamer, as a creator, whatever the hell you want to call it. I would never put a photo up that has somebody's watermark in it. I don't know. That's just weird.
Now, sometimes things are challenging. And this is going to be hard for you all to see. But this young lady right here should not have been left like that. This young lady deserves to have raised her children. This young lady deserved to have lived a life. This lady deserved to have continued to work, to be a part of her children's lives, her grandchildren's lives, but she is not. The defense has operated on what if this, what if these possibilities, what if. We want you to focus on what evidence came out of the trial, what the reasonable conclusion is, and you will not be telling him something he doesn't already know. For 27 years, he's known what he has done. For 27 years, he has sat and hid from justice. We are imploring you, we are asking you Don't listen to these fabricated stories for what the defense is telling you. When you follow the truth, when you seek the truth, there is only one true result. That this defendant, Mr. Wolfenbarger, is guilty of murder. And we're going to ask that you do that. Evil prevails when the men and women fail to act. I'm asking you to act. We are asking you to act. And we are asking you to find him guilty. Thank you.
Thank you. Ladies and gentlemen, I'm going to, in a moment, just give you the charge of the court, which is that law that I promised when I first swore you in to be jurors in this case. And I, too, have a PowerPoint. And mostly I do that so that people process things differently. And so some people hear things better and understand it by hearing it. Some people, it's helpful for them to see it. You will have a copy of these jury instructions with you in the are considering the case of the governing rules of law. Christopher Wolfenbarger. Now, the lawyers have referred to some of the governing rules of law in their arguments, and if there is any difference in the law that was stated by the lawyers and as stated in these instructions, you are governed by these instructions. Nothing I say in these instructions indicates that I have any opinion about the facts. You, not I, have the duty to determine the facts. You must perform your duty as jurors without bias or prejudice to any party. The law does not permit you to be controlled by sympathy, prejudice, or public opinion. All parties expect that you will carefully and impartially consider all the evidence, follow the law as it is now being given to you, and reach a just verdict, regardless of the consequences. Excuse me. You have been selected and sworn to try the criminal case of the state of Georgia versus Christopher Wolfenbarger.
Okay, I'm gonna be really rude.
That indictment. Really rude. Elected, chosen, and sworn for Christopher Wolfenbarger, 1999. Exact date being unknown to the grand jurors at this time. Okay. Did unlawfully and with malice aforethought cause the death of Melissa Dawn Wolfenbarger, a human being, by inflicting homicidal violence upon her in a manner unknown to the grand jurors at this time, contrary to the laws of said state, the good order, peace, and dignity thereof. Ladies and gentlemen, you will have the indictment with you in the jury room, along with a copy of these instructions and a verdict form. The defendant has pleaded not guilty to this indictment, and he denies every charge in it. This indictment and the defendant's plea of not guilty present the issue that you have been selected and sworn to decide. The indictment is the way the defendant is charged with committing crimes that violate the laws of Georgia. The charge in the indictment and the plea of not guilty are not evidence of guilt, and you may not conclude that the defendant is guilty based on the charge or the not guilty plea. The defendant is presumed to be innocent until he is proven guilty. The defendant begins the trial with a presumption of innocence in his favor, and this presumption stays with him until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendant is guilty of the crime charged. You may not convict the defendant of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in the indictment beyond a reasonable doubt. The defendant has no burden of proof at all, and the burden never shifts to the defendant to prove his innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the defendant beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based on common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which you can give a reason based on the consideration of the evidence or lack of evidence, a conflict in the evidence, or any combination of these. After considering all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must find the defendant not guilty. But if no reasonable doubt exists in your minds about the defendant's guilt, then you may convict the defendant. If the state does not prove the defendant's guilt beyond a reasonable doubt,
your duty would be to find the defendant not guilty. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented, and then you must apply the law that I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is how a fact is proved or disproved. Evidence can be either testimony or exhibits. Testimony is what you hear from people who take the witness stand and swear to tell the truth. However, the questions the lawyers ask the witnesses are not evidence. Exhibits are documents, photographs, or other physical items that are admitted during trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or the questions asked by the attorneys. Evidence may be either direct or circumstantial or both.
Considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that.
Okay. While I do respect the judge, let her continue reading.
Now retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence which has been admitted in this case. If you have any questions during your deliberations, please write them out and give them to the deputy. If you wish to take a break during your deliberations, please notify the deputy. But please understand that you may deliberate only when all of you are together as a group in the jury room. Deputy, please escort the jury to the jury room. And ladies and gentlemen, your lunch is there and ready for you.
Okay, with that, I don't think the judge will say.
Thank you all. The jury is clear. You may be seated. Any objection to the charge as I gave it from the state?
No, Your Honor.
From the defense?
The objections are the ones that we announced before. Are we preserved, or you want me to reiterate what they are? It was the.
As far as I'm concerned, they are preserved, Mr. Samuel. The objections that you have already asserted, you had preserved them when I said this is the charge I intend to give. You indicated that you continue to object, and I've of course now given them, so you can object again.
You want me to object again? Okay, the 404B instructions we requested.
Yes, sir.
There were 2 or 3 of those. And the prior difficulties instruction, we think both of which were necessary in this case.
Okay. I do, forgive me for interrupting, I do want to make a note. There was an objection during the closing argument, the second part of the state's closing argument, as to Ms. Hilton. The parties approached. I notified the parties that I would make a note of it and make a record of that objection. The objection was to I think it was a statement by the state regarding actions by Melissa Wolfenbarger in stealing cars, and that somehow that was with or for Christopher Wolfenbarger, I think was what I understood. The discussion that was had at the bench was, number one, that's 404B evidence that was never, that was not appropriate and would not have been admissible, but also I had not heard any evidence about Mr. Wolfenbarger's connection to those alleged car thefts by Ms. Wolfenbarger until that moment. In any event, the objection was preserved, and the party stepped back and the state agreed to move on from that issue rather than highlighting it by withdrawing it. Anything else you want to put on the record regarding that issue, Mr. McDermott?
No, Your Honor.
Ms. Hilton?
No, Your Honor.
Anything else for the defense, Mr. Samuel? I interrupted you, sorry.
You didn't interrupt me.
Okay.
Thank you.
Okay, so can y'all please make sure that y'all have all the evidence together, and that to get it ready to go back to the jury? Deputy, my understanding is that the alternates, Judge Williams has graciously agreed to loan us her jury room for the alternates.
Yes.
So you can, once they get their lunch, you can, and it's time for these jurors to deliberate, and we can take them over there.
Yes, sir.
Okay. If y'all can check and get the exhibits together.
Okay, so the time on the clock I noted, okay, was 2:42. All right. They, they don't make any announcement. They leave. We're watching the little time thingy go round and round, round and round, round and round. Okay, wait. 4:47, 48. Okay. My 5-second flips is making this thing move real fast.
Hey, ladies and gentlemen,
Okay. And what time was it?
I did forget my robe.
Okay.
Sorry.
About 2 hours. We're looking at about, she forgot her robe. That was cute. So we're looking at about 2 hours. Maybe even less than 2 hours. Maybe even less than 2 hours. Oh, look, see, look, I got somebody pinging in my ear, Miss Denise. That's what I was trying to figure out, is how long they were out. So about 2:40 to about 4:50-ish. So what, that's 2 hours and 10 minutes about. Okay. And she forgot her robe. So let's see what happened. Ooh, the TV went black. Okay. No, they're not out. This says they're in. So I haven't watched it. Here we go. Judge came back with no robe. You have perfect timing, Journey. Perfect timing.
Okay, ladies and gentlemen, I'm advised that we have a verdict from the jury. I believe that they're going to get my robe, and then I'm going to have the jury come out in just a moment. I just would like to remind the people that are in the courtroom, first of all, you've been very respectful of this entire process, and I very much appreciate that. But I do want to remind you all that I understand that a verdict can be a very emotional, people can have very emotional reactions to verdicts, right? Because we have people here in support of the defendant, we have people here in support of the victim. So I just want to remind you that when I read the verdict, I implore you to please maintain calm, not to shout out. And if you don't feel like you're going to be able to contain your emotions, if you could please step out of the courtroom until you are able to contain your emotions and step back into the courtroom. So with that, as soon as I have my robe, we will get started. Sorry about that.
Okay. Judge went to get a robe. Okay, Denise, I'm gonna pull it up.
All right, for the jury. Gerald, President County for the Honor.
Thank you all. Please be seated. Will the foreperson please stand? Good afternoon, sir. My understanding is that the jury has reached a verdict?
Yes, the jury has reached a verdict.
Okay, and was that verdict unanimous?
Yes.
Okay, and has the verdict been filled in, signed, and dated by you as the foreperson?
Yes.
Okay, will you please hand it to the deputy, and then you may have a seat, sir.
Okay.
Will the defendant please rise?
Okay, I'm sorry. Stop. I'm sorry. I'm sorry. What is he gonna do? No, wait. We do. Okay, y'all, I'm sorry. She said, will the defendant please rise? Ma'am, he's in a wheelchair. Is he gonna stand? I had to pause it because I don't know if he stands. I'm curious now. I'm curious as hell. Okay, that's so rude of me, but I just had to stop because I needed to take that moment. Okay.
In the Superior Court of
Here we go. Ready? I had to play it again. I'm sorry.
Will the defendant please rise? In the Superior Court of Fulton County, State of Georgia, the State of Georgia versus Christopher Wolfenbarger, case number 24 SC 004201. Count 1, we the jury find the defendant not guilty. This 22nd day of August 2025. Will the state and defense counsel please come up and look at the verdict form and confirm that you have no objection to the form or legality of the verdict?
Denise, if my dude stands, I'm gonna fall out. You called it. You're right.
Thank you.
Woke right on time, Maria. Yeah.
Counsel for the state, counsel for the defense, is there any reason that I cannot release the jury?
No, Your Honor. No, Your Honor.
Okay. Members of the jury,
Look at Norma crying.
I'm going to take just a quick moment to thank you for your time and for your attention to this process. It was a long 2 weeks, but I appreciate that you were here each day ready to pay attention and to do your job. Thank you very much for deliberating, for being here.
Sorry. I'm sorry. That's very disrespectful. This girl, I don't know. I don't remember who she was, but this one right here, and I mean, she's a heavyset girl. I'm a heavy girl. Go big girls. I'm a big girl, but she's getting that look around, like looking at everybody in the gallery. I didn't like that. I'm just commenting. I didn't like that. That was rude of her. The son's over here crying. I get it. I mean, this is very difficult, but this lady with her, I mean, that's not a place for snark and sarcasm right now. Judge just said y'all have been so good
here and for being willing to serve as a juror to your fellow citizens. I will also tell you, ladies and gentlemen, that in just a moment, I'm going to release you from further service as a juror in this case. I want to let you know that when you are excused, you are free to go. Enjoy your weekend. I want to let you know that you may be contacted by people about.
Okay, with that, I mean, it is what it is. We're going to pivot real quick and I'm going to cover. Yeah, he really got away with it, guys. I really felt he was guilty. That's, how I feel, but that doesn't mean, the jury felt. Like I said, I don't feel the state brought their case. I really don't. I think the state failed at this one. I don't think they had enough stuff behind them. It was a lot of circumstantial stuff, and yeah. All right, with that, we're gonna pivot real quick. I'm gonna watch one other thing, and then I'm gonna have to go because my house is getting a little unruly. It is almost 10:30 here. The other Menendez brother had his parole hearing today. Lyle. And I'm gonna play this video. There might be a little commercial at the very beginning because you know how news channels are.
Procedural delay, if you will, where the LA Times pool reporter who was there and providing the step-by-step of the hearing says that someone on the parole board erroneously sent out the audio tapes. If you're Mark Garagos, are you going to do something with that and say, hey, this is all moot at this point?
Send out audio tapes.
Well, I mean, look, if there are procedural violations that violate the privacy of the participants, perhaps you appeal, because at this point, the parole board decision, while it's final in terms of the current hearing, they have the right to appeal. And a parole decision is usually not final until 120 days. Right. So you use that fact to say, look, my clients have had their rights violated and we want a remedy. And the remedy is either give us a new parole hearing or reconsider your decision, and then try to maybe bring that up in the trial court. Because I also understand they file a writ of habeas corpus in the trial court seeking a new trial, and they can say, look, our rights were violated at the parole hearing. It's another reason to get a new trial.
Mm-hmm.
Well, yeah, and from what I understand, Marla, we've seen this kind of buried in there, but because that audio was supposedly released erroneously, that some of the family members who were planning to testify on behalf of Lyle
today
chose not to because they didn't want their private emotions and feelings.
So so the audio from Eric's got released? Is that what I'm hearing? I must have missed that. The audio from Eric's got released, so they didn't want to go on and testify for Lyle for fear of their stuff getting out there. Y'all have a bite your tongue, Sheila. Let this play.
Broadcast, which sort of goes against the fact that they all had plenty of news conferences that we all carried, sharing their emotions publicly, but still. So yeah, the chief counsel of the parole board, I believe that's their title, has 120 days to review this whole process. And as Dimitri was just saying, could make a decision that changes things.
But bottom line, Dimitri, it sounds like Garagos will use this as an even bigger reason to appeal.
Yeah, I bet he will.
Listen, when you're a defense lawyer, you work with what you have.
Right.
You don't have much. He's been given a gift. It's a violation of the parole rules and perhaps people's privacy. And so you argue what you have to say, look, they deserve a new hearing or they deserve a new trial. Get us bail, get us out of prison. As a defense lawyer, you're going to do everything you can for your client. And of course, it would be proper for him to raise these violations that the state committed.
Do you think they should be paroled?
My experience, look, I was a prosecutor. I prosecuted people that committed murders, and also I've defended people that have committed murders.
Right.
I think that the unique part about this case, two unique things. A, allegedly victims of sexual abuse. I don't know how valid the sexual abuse claim is. I question that. Right. Obviously, if they're victims of sexual abuse, that makes me want to say they should get parole. But it's not something they raised when they were arrested. It's sort of like a claim that just, on the one hand, in my mind, might have been made up. The second issue is youthful parole. That's a new issue in California, new law. And people that commit crimes under the age of 31 have a youthful parole hearing. I have had a lot of clients sentenced under that, but they're still sort of waiting for their parole date. If the state has made a decision to give people youthful parole hearings, then the parole board should really give that a lot of weight, because before, when they weren't releasing people convicted of murder, that youthful aspect was not really part of their decision making. The issue I have with this case is how much weight did the parole board actually give their youth? Because the state legislature has made that a larger factor, a bigger variable. And it's not clear to me, they're looking at the cell phone violations. I get it, but there was no determination and no weight seems to be given to their age, which is what the state is now saying should be given great deference.
I thought it was 26. You said 31, but we could double check that. But your point is well taken.
Well, the point is at 31, you can apply. I have clients that have, say, committed a murder at the age of 19, and they can start applying at the age of 31.
Okay.
Here, they definitely were under the age of 26. I don't know exactly, but they were younger.
18 and 21,
and the state has now said, look, you have to give the age aspect a lot more weight than before. And I just didn't hear the parole board give that any consideration or any serious consideration. It seemed like the focus was, okay, they were in there for life. They violated, cell phone rules and perhaps other issues. But the weight of the evidence is, look, they were very young.
I mean, and I had heard that too. I had heard that they had violated something that they had said last night over Eric's was, that some of the things that was against him in the parole hearing was that, he had some cell phone violations. There was some drug or alcohol abuse or something to that effect. There was a few write-ups, shit happens. He's been in there for a long time, but y'all, I don't even know what to think.
And what the parole rules say is, it's actually encoded in the parole regulations, is people under the age of 26 have a different sort of brain chemistry, and social science has shown that because their brains aren't fully mature, you should give their age a lot more weight. And that wasn't considered by the parole board, from what I understand, and given that great weight. So
Yeah.
I'm wondering why that wasn't considered.
And what about the fact that, like Eric, Lyle will be up for parole in 3 years, and they could have gone as, I believe it's 15 years for the next parole hearing. They could have made that decision to wait 15 more years. To your point, if you commit a double murder, it's highly unlikely you will be paroled. I mean, do we just go through the song and dance of all this again just for the sake of it?
It happens all the time, guys. It happens all the time that people that have life sentences are going up for parole hearings and that they don't get released. So you're absolutely right. That's how the system works. Unique thing about this case is it's high profile. So you have the Menendez brothers, this horrible murder in Beverly Hills. But the reality is the other 99% of the cases that people are convicted of murder are sitting in prison, they're not getting paroled. It's just people are obviously folks in this case, you have the...
Yeah, and I see that too. A lot of people are hyper focused on this case as it's a very public and well-known case. And then you have others that have been sitting there for years that would like to try to go up for parole, but don't.
Elephant in the room, the sexual abuse. So it's very sad and tragic if the sexual abuse is true and they're still sitting in prison.
Well, I heard a really interesting comment today by one of the legal experts that was talking about this, that depending on your own life experience, like an older generation that I guess I would put myself in, that lived through all this, terrible shotgun murders, right? Prison for life without parole, lock them up, throw away the key.
Spending
Absolutely.
spree, yes.
Then the younger generation that may not have been even aware of it or alive then or paid attention then, and then they saw the 9-part monster series on Netflix, very sympathetic to the
all
brothers.
Of the TikToks.
Now that generation has much more sympathy. Yeah, let them out. So it's really kind of divide there based on your
age,
your sort of life experience. And then we
pop up with the nowadays we have social media. Now imagine if they had social media back when these crimes were committed. What would be different about this? It would have a whole nother, I mean, not even a compare, but look at Gypsy Rose Blanchard. I mean, and now we have, unfortunately, copycats of her. But she had social media during her time, although it was not as well developed as it is now. There was still social media, and that was all lit on fire, even when it happened. So the social media wasn't around, but the news outlets made this very visible to us that didn't have social media back then.
go through this whole thing, and let's say the decision is yes, then it becomes a political issue because the governor can just reverse it anyway, which seems to undermine the whole process.
So let's just get clarity
Newsom has that power.
on Newsom right now. So he can, the only way that this would change the course of their fate would be to grant the both of them clemency. Is that right?
Right. They can get clemency from the governor, which is probably unlikely. He's running most likely for president in the next election cycle. And then B, they can apply for writ of habeas corpus. And my understanding is they have already to the trial judge, Michael Jessic. And then that trial judge can make a decision that, hey, they didn't get a fair trial. This evidence should have been introduced. Therefore, give them a new trial, reverse the convictions himself, and then give them bail. That's another way for them to try to get out.
Yeah. Dimitri
Thank you so
Gorin,
much.
yeah, you're great help. Thank you so much for jumping on the air with us.
Sure, guys. Of course. Thanks for having me. Have
Yeah,
a
we'll
great
talk
night.
soon. More for sure on this.
Oh, yeah.
All right. So new tonight, right?
All right. Yeah, that was interesting. And you know, Cindy has a point. The recognizing sexual assault, which I'm not ashamed to say it, was different way back then than it is now. I can honestly say, as a survivor, as a child, a young person, you know, things are so different now to be able to talk about things and therapy and things that we have available to us that was not available back then, wasn't presented back then. I know as a teenager, when my parents took me at 13 years old for a psych eval, love it. You know what they told them? I was a hormonal teenager. Leave me alone. And here I am, 53. 40 years later, I'm still a bitch. Nothing's going to change. So I'm still a smart ass. I'm still snarky. I have my bubbly attitude, and that is me. That is who I am. So with that, I want you all to have a great rest of your night. He was found not guilty. I don't agree with it. It is what it is. I don't know about y'all, but I haven't watched the Young Dolph trial. I do know the verdict. I do know the outcome. I'm not sure how it got there. But I'm kind of thinking about if I don't find any good trials to start on Monday, we may go back and I will speed trial the Young Dolph, and we'll just knock it out next week. And, however, 4 days or whatever it was, just speed trial it, just because I'm interested in how they got to the verdict in which they came. So with that, I want y'all to have a great rest of your night, great weekend. And until I see y'all Monday, because I don't think I'm going to be back on over the weekend. Rubber out. Y'all have a great rest of your night. Thank you.
Life's a ride.